Good afternoon, good morning. Welcome back sa ating lecture room po. No? Today is September 10, 2023. Sunday is already 4:23 and I'm late again. Sadya na, no? So, ngayong araw mo ito, pag-usapan mo natin yung napili ko na question by one of our subscribers and friend na parati pong umaten po sa ating live. No, katulad po ninyo, nag-attend po ng live natin ngayon. And ito po yung katanungan ni Severino Sabes, no? Ito sa question 7 days ago. I want to emphasize this question niya kasi good afternoon attorney, no? Ask ko lang po kung compulsory heirs ba ang mga kapatid kasi single raw siya, patay na po daw ang parents niya. Gusto niya ipamana ang mga properties niya sa isang kapatid at dalawang pamangkin lang out of 5 na kapatid sa 8 na pamangkin. No? So, well, I was able to answer this very fast. But I would like to emphasize more today para maintindihan at maklaro po natin na mabuti ito. So, compulsory heirs nga ba ang mga kapatid kapag sa property mo, kapag mana ng property mo, no? Well, actually, the answer is no. They are not compulsory heirs, no? Ang tawag po sa kanila sa batas is collateral relatives, no? They are called collateral relatives. Okay. Hindi sila compulsory heirs. Ang ibig sabihin po kasi ng compulsory heirs, let's say walang will, ha? Pag namatay, the compulsory heirs listed under the law are the surviving spouse, of course, the legitimate children, the legitimate descendants, kung wala, legitimate ascendants, no? So, ibig sabihin, yung legitimate descendants, mga anak, bababa, kung may asawa, tsaka yung illegitimate children nung namatay. Kung wala pong legitimate descendants, pababa, paakyat po tayo doon sa mga ascendants, no? Sa parents niya. So, yun po ang compulsory heir. Ibig sabihin, kapag wala pong will, last will and testament, sila po yung magmamana, no? One excludes the other. Kung meron lang, the rule lang is that kung may descendants, yung mga ascendants, yung nasa taas, hindi sila kasali. But, nevertheless, always po, ang compulsory heir po ang asawa at compulsory heir po ang illegitimate child ng namatay. So, ibig sabihin po, ang asawa lang dito ang hindi kadugo niya but considered by law as a compulsory heir. So, ano po ba ang trabaho nitong mga collateral relatives? Bakit nandyan pa sila sa ating batas? Well, they are collateral relatives because they come into succession kung walang last will and testament kapag wala pong mga compulsory heir. Reserve ba? Parang pag walang compulsory heir, then they therefore inherit in lieu of them. Sila ang papalit kasi wala namang mga compulsory heirs. Okay? So, yun po ang collateral relatives. Although there are instances na magkakaroon po ng mixed compulsory heir plus the collateral, no? For example, kung wala po silang mag-asawa, walang anak, and then namatay po yung, let's say, the husband, tapos buhay yung surviving spouse, in that particular case, dahil wala silang anak, wala rin ascendant pataas, the compulsory heir comes in to inherit, no? Part of the property together with the surviving spouse. Yun lang po, no? Now, take note, but still, they are not considered as compulsory heir. Now, yun lang po masabi nating mandatory heir sila kapag in that particular situation, yung kinento ko, or nailagay po sila sa last will and testament. Okay? So, having said that, ito patuloy natin ang tanong ni Severino Sabes, no? Single raw siya at wala siyang mga anak. Okay, ibig sabihin, wala siyang asawa at wala siyang mga anak. Patay na ang parents niya. Ngayon, marami siyang mga properties. Ang tanong niya ngayon is, pwede ba niya ipamana ang property sa isang kapatid niya at dalawang pamangkin lang? And meron siyang 5 kapatid and 8 na pamangkin. And baka ginawori ni Severino dahil yung legitim. Well, no, because they are not compulsory heirs. So, wala pong legitim na pag-usapan. Go ahead po, pwede po mong ipamana ang property mo sa isang kapatid at 2 pamangkin mo lang. Gawa ka ng last will and testament, either holographic will or yung sulat kamay mo. Make sure it's dated under your own handwriting and must be signed at the bottom. At dahil techie na tayo ngayon, paki-ano na din, paki-video na lang din, no? Para at least maging secondary evidence to prove the execution of this holographic will. You don't need to go to a lawyer. Now, ang maganda na kasi pag notarial will is that ang execution you presumed to be regular and it's a public document, no? So, if you really want to go to a lawyer, ganun din. In my case, as a lawyer, notary public, what I do is that binibidyo ko rin ang pag-execute niya, no? Of course, with the permission of the testator, no? Kasi meron kaming formalities required under the rules on succession, no? If I follow for notarial will. So, dalawang klase po, holographic or notarial will. Pwede rin po, Mr. Sabes, is that ang gawin mo is pwede ka rin maggawa ng deed of donation, mortis causa. Or it's kind of deed of donation with the condition na while pwede mo ilipat sa pangalan nila, but while you're still alive, you hold the usufruct of the property. Lahat ng mga income benefits on that property, you own it, no? It is your benefit, no? Not for them. Sa kanila, naked ownership lang ang binigay mo. Pero yung paggamit at saka mga income and benefits on that properties that you have, pwede sa'yo habang nabubuhay ka. So, marami pong mga ways, no? O sabi nga nila, there are 1,000 ways how to kill a cat, no? So, ang dami pong way, no? Para maipatupad po ang kagustuhan mo. Now, take note that ang importante lang maintindihan natin, hindi po sila compulsory heir at hindi po sila dapat magalit kung sakaling hindi ibigay ng pantay-pantay sa kanila, no? Okay, because they are only collateral relatives. You have the decision, Severin o Sabes, to whom you want to give. You can even give to a stranger, to anyone else you would like, because there is no legitimate to speak about. Okay? So with that, I am done with the question of the day, and we are going to discuss now we are going to hold the live session already. So let us see kung nandito na ba yung mga kaibigan natin, no? Let's say sandali muna. Let us put this down and we will see the docs if they are here. Na ba dito? Okay, sa chat box. Let us see if our friends are here. Okay. So, I think wala pa. Oh, nandyan na. Here are my friends right now. Kumusta guys? How are you? Nag-ano pa. So, ano po, ang number one ngayon natin, based on my chat box, no? Si Success Aura. Magandang araw at magandang araw din, Success Aura. Greetings from Singapore. Wow. Very nice country. I love that country. Napakalinis, orderly and very advanced, no? Thank you, Success, for that greetings. Ferdinand Valencia Imperial, these are the usual friends natin. Good morning also to you. And si Merlita Arellano, good morning, attorney. 4:11 ng umaga na po ako nagising. Okay po, walang problema. Okay, diretsahan na kahit si Merlita. Tanong niya, attorney, nagtataka lang ako. 1972 pa ginawa ni Senior Marcos ang Emancipation Act. At ano ang nangyari since then? Bakit ngayon lang ito daman ng mga taong bayan? Anong ginawa ng ating gobyerno before 2016? I'm just wondering. Well, basically, hindi masyado nararamdaman. Actually, nararamdaman in a sense, no? Kasi ang Emancipation Act, yan yung unang batas, yung PD 26 na ginawa ni President Ferdinand Marcos, the father, no? And agad DAR Secretary noon si Mr. Estrella, who happens to be the DAR Secretary now ni Bongbong Marcos also. Ang purpose nun was to give lands to the landless, no? And yun nga, nung nagkaroon ng Comprehensive Agrarian Reform Program, napalitan ito. However, ganun pa rin ang principle, no? To give lands to those who have less in life. Kaya lang, kung bibigyan po ng lupa yung mga beneficiaries, yung qualified beneficiaries, and they will be awarded with this CLOA, hindi po libre yung titulo, no? Yung pag-award ng lupa at saka yung lupa itself, may bayad po yun, no? And you have to pay for amortization for 30 years, no? Kaya sa land bank. Kaya nga, ang titulo na sa land bank at naka-annotate doon na may utang. Parang naka-real estate mortgage, okay? So you have to pay that. Now, if you cannot pay, it's possible that the land bank may foreclose it. Kaya na foreclose, no? Maganda lang dito sa bagong batas na pinasa ni President Bongbong, tinanggal na lahat ng pagkakautang. Tinanggal na lahat ng penalties compromise na hindi nakababayad. So, wala ng penalties, wala ng surcharges, wala ng interest. At the same time, wala na talagang utang. So, it is actually condonation, no? Everything done, no? Hindi katulad dung sa amnesty is that may babayaran pa rin tax, pero wala na amnesty lang sa mga penalties and interest, sa estate tax amnesty. But here in this new law, yung sa paglibre na ang pagbayad sa lupa na binigay by the DAR is that totally free talaga siya. And ang maganda dito sa batas na ito is that i-absorb ng government ang pagbayad doon sa mga landowners na hindi pa nababayaran because their property was taken, their private property was taken through tawag dating eminent domain, taking of property for public use and given to under the principle of social justice to those who have less in life, no? So it's also a kind of emancipation pattern, but before talagang kailangang babayaran, but right now free na talaga siya. So, yun ang maganda lang, no? Kaya lang natin medyo naramdaman na mabuti, Marlita, because of the fact that itong bagong batas na nilibre talaga ni Bongbong Marcos ang pagbayad dito sa mga awarded lots, no? Okay, si Ferdinand Imperial, kung wala pong administrator or administratrix, okay, kung administratrix po babae, administrator lalaki, ang agricultural land, ang DAR po ba ang tumatay ang caretaker nito? Okay, I do not understand your meaning, no? Kasi ang alam ko na administrator po under the law is simple, no? Is a court-appointed administrator of the property. When meron pong namatay, no? Let's say, namatay may-ari, sino magiging administrator of the property? Sometimes pag hindi nagkasundo ang mga heirs, they have to go to court for judicial settlement of estate and partition. They will also be praying na ako maging administrator nitong mga properties na ito. Kung nagkaintindihan naman, walang problema kasi they will just execute an SPA to one person to act as the administrator, di ba? Of course, he does it, the administrator or administratrix do it for the purpose of interest, no? Para dun sa mga heirs. Kasi ang purpose niya, i-gather lahat ng properties, pay all the taxes, pay all the debts, pay all lahat ng mga pagkautang, and then ang sobra po, i-distribute sa mga heirs. Yan naman ang trabaho ng administrator. Now, hindi ko maintindihan kung agricultural land, ang DAR po ba ang tumatay yung caretaker? Now, this is a new thing to me. I think there is no such thing, no? Na ang DAR lang po ang tumatay yung caretaker nito. Alright, so take note of that, ha? And we will question ni Juan de la Cruz, no? At any good PM, nabili po ng kaibigan ko yung property by deed of sale na signed ng mag-asawa noong 1991. Sa ngayon po, patay na yung mag-asawa at the-transfer na po yung title noon pa 1991 sa friend ko. Okay. So, title ng property sa kanya. Ngayon po, 2023, gusto habulin ng anak nang namatay yung property sa reason na sa date daw na notarize yung deed of sale ay patay na yung mother niya. May habol pa kaya yung anak? Yan ang problema. Because if that is the case, that the time of notarization or the time of signing of the deed of sale, if one of the conjugal owner of the property, in this case, yung wife, no? Her signature appears therein, pero patay na siya. Klaro po ang storya, her signature is forged. Now, if it is a forged signature, it is an invalid document. It doesn't matter if it has been notarized or not by a lawyer. Hindi na yung rule on defective, no? The rule of that fact is that it is an invalid sale transaction. There was no transfer or transmission of rights, no, in favor of the buyer. Kasi, bakit po? The rule is that in order to sell a property co-owned by the spouses by way of conjugal property, all spouse must consent, no? In that particular case kasi, kung patay na si mother at pinorge ang pirma niya, invalid yun because ang heirs noon ang mga anak. No. So kung meron silang anak na si apat, kailangan ng consent ng apat. So in that particular case, not only does kung patay talaga ang mother, it did not have the consent of the children as the heirs also. Compulsory heirs, di ba? Yun ang na-discuss natin. Now, kung in that particular scenario, dahil void po siya, ang tawag po niyan imprescriptible. Hindi po mag-prescribe yung action ng anak na habulin yung property. Okay, so, it's possible po na yung pag-transfer ng title is manannullify ang title. Okay? Now, Juan de la Cruz, your question, I answered it based on the facts that you have presented me. No? It would have a different opinion if all the facts and documents are presented before me. So, medyo generalized po yung question nyo. General po ang sagot ko. In this particular case po, pwede po habulin. Okay? Take note of that. Alright, si Juby Labial. Kasi po, okay, nag-process po daw sila ng EGS. Matutuloy ba yung hatian na isali yung kapatid na walang beneficiary? Na yung isang kapatid di po agree sa gusto nila mangyari sa hatian? Okay, Lavial, I think you have, siguro meron kang previous question po, no? Kasi po, ang start ng answer mo is kasi po. And I do not see any, I did not see na yung first part ng question mo. Labial, from Barin po siya, no? Watching from Barin. Pwede mo ba bang i-complete ang question? Because I would like to answer this. It's a very interesting question, no? You post it immediately now habang konti pa ang naka-post, okay? I will answer that, Juby. Oh, si Severino. Ito po yung ating questioner of the day, si Severino Zabes. At meron po siya pahabol na question. Si Severino, sabi niya, Attorney, pwede ba isama sa last will and testament ang mga riyan na mamanahin ng gagawa ng last will? Ay, hindi po. Pag mamanahin pa ha, iba po yung minana at mamanahin. Ibig sabihin, mamanahin, it's a future inheritance. Hindi po yan siya makonsidered na property owned by that particular person, no, na magusto niya isasali sa last will. Hindi po. Kasi ang right po niya doon sa mamanahin niya is inchoate. Okay? Inchoate pa, hindi pa nag-ripen into a full right na siya ang owner. Hindi po siyang may-ari pa. So, kaya nga, yung future inheritance are not part of this kind of succession rules. No? So, having said that, ano lang po yung namana na, okay? Namana na natanggap na or existing properties niya for that matter, including yung namana niya, yung nabili niya, and everything, yun lang po ang subject po sa last will and testament. Meron pong gumagawa po ng statement na sa last will na and all future properties that may come into his possession. No? But take note that it should come into his possession at the time that he is alive, o ownership and possession, that would be included in the last will and testament. No? But if you define na specifically na yung mana ko from this particular person, which is a house and lot and everything, hindi po pwede yun. Do not expect that that property will be given to you. Why? Because it's possible na yung mamanahan mo is ibebenta niya dahil buhay pa man siya, right? So, inquit nga, expectancy pa lang. But it is not prohibited to state in the last will and testament that, and I will give this to my pamangkin and any and all properties, okay, that I may acquire in the future while alive. Okay? So, in that particular scenario, pwede po maging valid yung particular stipulation na yan. Kaya nga, ang sinasabi ko sa aking mga clients and friends that kung gumawa sila ng last will and testament, they could always amend it, no? Or create ng addendum. Or otherwise, create a new one para mag-reflect yung mga bagong properties na acquire. Or para hindi na reflect yung mga property na nabenta. Na kasi, along the way kasi, even if, let's say, may last will and testament na ibibigay dito sa isang pamangkin, it doesn't stop you as the giver of that property to sell it, no? Wala mang mag-stop sa'yo kasi wala man in Kuwait pa man din yung karapatan nila kasi kailangan mamatay ka man para makuha nila. So, still you're alive, you could still sell it. So, kaya nga, pinapa-amend ko sila kung may nabenta na or may na-acquire na bago. Okay? So, take note of that. So, Noel Cabigas, good morning. Noel is my friend also. Si Noel Cabigas and si Merlita Atiliana. Attorney, I've been watching almost your channel since 2022 topics. How to get the entitled is very sensitive and very tricky. Why these wicked people, they can get the OTC title just like that at DAR? Why? Well, it depends upon the circumstances, Merlita. May mga situations wherein merong areas na mas mabilis mag-process, but we have to give all the presumptions of the regularity in the performance of their duties. No? We cannot conclude that money has exchanged, no, between the parties and that particular government agency because it would be unfair. We need to establish the fact that they have been doing their job really, no? Unless there is a solid proof that indeed there is corruption that happened, then there's a time that we have this cause of action to file against them, no? Against them for administrative action, no? Disciplinary sanctions, no? And then because I still believe that our government is trying to change, no? Our officers are trying to change and trying to do what is best. So, ang akin naman, baka kulang ang mga requirements. Sometimes kasi, we tend to sisihin kaagad natin yung government agency kapag kulang tayo ng hindi pa nalalabas yung pinaprocess natin. Yung pala kulang din ang mga documents ninyo and everything, doc requirements, etc. At the same time, mali rin ng government agency because hindi rin sila nag-notify ko anong mga kulang. Yung mga things like that, no? But it doesn't mean na kung may konting negligence on both parties, it doesn't mean that there is corruption. May kapabayaan pero walang corruption. Kaya minsan tumatagal lalo. Ma'am, nag-follow up ka after 1 year. Ay, may kulang po pa kayo? Ba't di nyo ako sinabihan? Pwede rin sabihin sa inyo, bakit di po kayo nag-follow up? Parang ganun. Pero actually, trabaho dapat ng government agency to inform us, to deny, because meron man tayong period within our talo, no? Within which to do it. Kung pending siya or nakahang siya sa kanilang task sa computer, then they have to inform or either approve or deny. Kasi yun naman ang trabaho nila eh. Kung yung transaction na in-apply mo is allowed, approve. Kung hindi, kulang requirements or invalid or void, then i-deny, reject, no? Isauli sa inyo. And they have to inform you in writing. Kung hindi niya nagawa doon, maybe merong konting negligence, but it doesn't mean that there is, it doesn't necessarily mean na merong corruption there. Okay? Yun lang po, no? Kaya nga, with the modernization of our government agencies and pag meron ng computer na maghang siya at magre-remind sa kanila na this particular transaction has been pending for some quite time, then they will be reminded, then they will be forced to notify the client. Ang tawag po sa atin nila is client that either the transaction has been approved or denied. Okay? Take note of that. Good day, attorney. Idol, sabi ni Phil Star, Real Estate Brokerage. Bye, mayong buntag sa imuha. Thank you so much. Sabi ni Noel Cabigas, attorney, magkaiba ang pirma sa notarized DOAS at deed of donation. Iisang tao. May kaso ba? Well, it depends, no? Kasi sometimes, merong different kinds of signature ang tao na merong iba may signature na full signature talaga. And may iba, initial lang. Ako, I have 2 signatures, 1 initial and 1 complete signature. And we are allowed, no? Because as long as that we register that with the clerk of courts for notarization purposes. No? Ay, Bordante po, merong same ang stroke and style. And there is proof that once upon a time, yung pirma na yun is the pirma niya. Now, if you are saying that there is really difference in stroke and style, talagang klarong iba talaga. Now, based on evidences you have, yung mga previous signatures niya noong unang panahon, well, in that case, there is a case, no? There might be a case, no? And you can file for a falsification of document kung ginamit yan, no? To get something, some benefit from that execution of that signature, either sale or transfer or mortgage and lease and everything. Kahit anong contract where there is a transmission of certain right, tapos pinorge ang signature, na klaro talagang forge, talagang totoong forge, no? Then, that particular case, may kaso po, no? Okay. Si Jemlyn De Los Reyes, watching from Hong Kong, attorney. Yes, Hong Kong. I love this place also. Ngayon lang po kita natagpuan na live po kayo. God bless you. Jemlyn De Los Reyes, yes po, nagda-live ako. I'm trying my best to be ready by 3 o'clock. Ngayon, late na naman ako. 4:20 ako naka-open. Kasi nilakwat ko muna yung aking mga kaanak, no? Babies natin, no? Kasi Sunday, no? But nevertheless, I always find time for all of you guys to at least somehow answer your questions, no? But remember, your questions that you present to me, please wag po kayong magsabi kung sino yung tao and everything. Plus, just state it couch it in general terms para hindi ako mag-alanganin magsagot. At saka please, pakompletuhin nyo na kasi once na ilagay nyo dyan, tapos hindi nyo na kompleto, hindi ko na masagot, sa ilalim na po yung question ninyo. So, mag-graph po kayo ng question. Gaya nung ginagawa ni Merlita, yung may 1/2, 2/3, 3/3, para may makita kung trend kung maputol-putol man, no? Alright. So, si Wadas, ay, akong amiga, kumusta? Paano ba ang proseso nito? Scenario number 1. Tax deck of Juan, okay, donate kay Adela with deed of donation. Okay. Patay si Juan, pero hindi nilipat ang tax deck sa pangalan ni Adela. Okay? Binenta ni Adela kay Lisa ang lupa with DOAS, buhay pa si Adela. Okay. Paano ilipat ang tax deck kay Lisa? Maraming salamat. Well, remember, kailangan po natin ng link, no? From kasi ang ending kasi niyan, ang sabi mo dito, si Lisa ang last na kabili. So, from Juan to Adela, Adela to Lisa. So, there must be a linking document there. So, if the tax deck is under the name of Juan at dinonate niya kay Adela, may deed of donation, di ba? Or may waiver of ownership or transfer of rights, no? Or waiver of rights for that matter. What is the right of Juan waiving? The right of possession and even the ownership, no? The claim of ownership of that property. May deed of donation, which must be in public instrument. Now, that deed of donation is from Adela. Yun ang basis na Adela in selling it to Lisa. Siyempre naman, kung si Lisa, bago niya bilihin kay Adela, binibenta mo yun, ano ang patunay na ikaw may-ari nito? May deed of donation ako. Yung deed of donation, tingnan natin kung sakto ba pagkagawa. Okay, pag saktong gawa na ng deed of sale. Now, sa deed of sale, sabihin po doon, dapat na that the seller and the buyer, no? That the seller is the owner of a parcel of land untitled, unregistered, covered under tax deck number 12345. Still under the name of Juan. However, this is already owned by the seller by virtue of a deed of donation herein attached as Annex A to form as an integral part of this contract, this deed of sale. Para ma-establish ang link, no? From there, so paano i-transfer ang tax deck? Well, you have to follow the rules on transfers. Sabi ko nga sa inyo, hindi lang po yung registered land ang kailangan ibayaran ang taxes sa BIR. So, the donor's tax should be paid from the original tax deck owner to Adela, bayaran yon. Then, from Adela to Lisa, kailangan din bayaran para once mabayaran at may e-card na po tayo doon, dadalhin po natin yan sa Registry of Deeds. Bakit? Ang Registry of Deeds po, nililista nila doon po yung mga transaction sa bilihan ng lupa, whether or not registered land or unregistered land. Ibig sabihin, tituladong lupa o hindi tituladong lupa. Now, kapag hindi tituladong lupa at na-register nila, may libro po sila for unregistered lands, bibigyan ng certification na nakabayad ng e-car and everything at na-register na ng ROD. Yun pong certification na yun, ibibigay po ninyo sa local city assessors or municipal assessor para po yung tax deck na nasa pangalan ni Juan de la Cruz mapapalitan papunta kay Lisa. Okay? So, yan po ang procedure, Miss Wadas 5. And si Nardina Estrella. Kumustamos, Nardina? Thank you again for tuning in. Okay. Si Renans, good afternoon, attorney. Tanong lang po, apat ang heirs, tapos nag-waive of rights ang dalawa, subject pa ba ng donor's taxation? A very good question. And the answer is yes. Anything that you waive, any right that you waive on a piece of property, whether it is a registered or unregistered land, titulado, hindi titulado lupa, the moment you waive it to another person, it is subject to a donor's tax. Okay. Karen G. Kumusta, Karen? Long time, ha? Tagal-tagal ito si Karen nakatune in. Nakatune in ka ba last Sunday? Hindi ko napansin, but I think. Oh, ito si Familia Lacuachere. Dito nag-absent. Attorney, ano po mangyayari sa hatian na magkapatid? Kapag namatay ang tatay na nag-donate sa mga apo ng share niya ng lupa sa namatay niya na wife. Okay, iklaro natin, ha? Ano po ang mangyayari sa hatian na kapatid? Okay. Kapag namatay ang tatay na nag-donate sa mga apo. So, dinonate niya sa mga apo ng share niya ng lupa sa namatay niya na wife. Ano po, bakit po tayo magtatanong sa hatian na magkakapatid kung dinonate na sa mga apo, no? So, kung dinonate na po sa mga apo, ang share niya ng lupa sa namatay niya na wife, kasi compulsory heir siya sa wife, sa apo na po yun. Yung mga kapatid po, wala na po, hindi pwede na sila magsali kasi donated naman. Attorney, kung may limit sa ownership ang foreigner, ano ang gawin kung ang property na inherit sa former Filipino more than 3 lots na sa rural area? Mapunta ba ang excess sa kanyang mga co-heirs? Kung may limit sa ownership ang foreigner, I think you're referring to a former Filipino, no? Ano ang gagawin din kung ang property na inherit ng former Filipino more than 3 lots na sir? Hindi po. Walang excess rule diyan kasi once if it is inherited property, yung kasing nasa law wherein they could acquire, ibig sabihin po yung acquisition by purchase. Inheritance po, it would be more than that area, possible po yan. Kasi ang rule on succession kasi, kapag walang last in, wala man, di talaga sila pwede sa last will and testament, ang mangyari po kasi is that it would entail a matter of right to succeed on the property. So, kung malaki masyado yung property ng former na mamanahin ng former natural-born Filipino citizen, he will accept it because it's a matter of right under the rules on succession ending. Okay? Samson U. Pwede po ba na yung actual position ng building, pwede po ba yung actual position ng building structure ang sundin sa untitled land nang hindi pinapalitan ang DOAS kahit mag-iba ang boundaries? Patay na kasing seller at di na makapag-issue ng bago. Well, alam mo Sam, no? Ang pinaka-importante in a transaction, no? Guys, pakinggan nyo ito. Kapag meron pong usapan, kung ano po yung intention ng parties, kapag ang transaction ng sale is itong lupa na ito at ito ang dimension, yun po sundin. Now, in case po yung building structure is lumampas doon sa napag-usapan, then that is what we call encroachment. Now, patay na po yung seller at di na makapag-issue ng bago. Well, you can always go to the heirs, no? And talk to them about it. Kasi hindi pwedeng i-insist mo yung position ng building doon kahit na untitled land. Kasi kapag mapansin ng mga examiners o ng mga tao na nag-examine doon sa document ng sale ninyo, that or any other person for that matter, na ang sukat niya ay klaro at hindi yun ang actual location ng building, then therefore susundin talaga yung nasa DOAS. Now, pero kung sinabi sa DOAS na I'm selling this land to Samson New, where the building is located or situated, and therefore, it means yun pong actual position ng building structure ang nakalagay. So, depende, Sam. Ano ba ang nakalagay sa deed of sale? Gusto kong malaman kung ano ang pagkasabi doon sa deed of sale so that we could interpret it properly. Kung saan po ang tamang interpretasyon, kung sa actual position ba or doon sa nakasaad sa technical, somehow parang location of property as stated in the DOAS. Okay? Pinoy Vigilante. Good afternoon, attorney. Marami po kayong natutulungan tungkol po sa batas. God bless and more power po. Maraming salamat, Pinoy. Please, it's the first time that I saw you, and please continue watching, no? And please share also your knowledge to everyone, okay? To other people, mga friends, relatives mo, ha? Okay. So si Git Bill. Baka mali ang pagka-pronounce ko, Gitzibil, no? Paano po ba yung last will and testament ay executed sa Amerika at notarized? Applicable po sa Pilipinas? Yes po, for properties in the Philippines, no? However, ang last will and testament na na-execute sa Amerika by rule on Lex Loci Celebraciones, kung doon po siya pinrobate, ang kailangan naman is yung decision ng probate court ipapatupad dito sa atin, no? Now, kung ipaprobate yung last will and testament dito po sa Pilipinas, ano po ba ang magiging basis sa susundin, no? Would it be the laws of America when he did it? So kung ginawa po ni notarized and it was patterned at the laws of America, then it will still be valid. But they have to prove that it follows the rules. So ibig sabihin, kasi po, even our last will and testament, disposing of properties in the United States, they accept it also. So kaya nga, we can make a last will of testament of all properties, whether situated in the Philippines or not. Okay? As long as it complies with our requisites here in under Philippine setting and validly proven there that this has been nagpasok po dun siya sa tinatawag nating formalities required under the law, okay lang sa kanila. Kaya nga, pag last will and testament po ang usapan, ang usual requirement ng foreign countries, including us, kung doon ginawa, we are a foreign country from the US, is that the decision of the probate court. That's the time that they will have to file a petition here for recognition of a foreign judgment, and therefore, i-execute po natin yan dito sa Pilipinas kung ano po ang gusto. Kasi the proper court that would determine its validity would be the court for which that particular instrument has been executed in accordance with their laws and formalities. Okay? Take note of that. Sylvia Villamante, saan po ako dapat ask ng help kung ang kapitbahay ko ay inalis ang muhon at nag-move ang muhon at inilipat ang barbed wire ko? The muhon and barbed wire was done on the day of the relocation. The putting of muhon and barbed wire was done on the day of the relocation survey. That's the problem. Kung nag-relocation survey sila at binunot ang muhon, well, alam niyo po, under our laws, revised penal code, you cannot remove any monument that is punishable by law. Pwede pang pailan ng kasong kriminal. Kasi even if there is a relocation survey, there must be kasi dapat ang nag-relocation survey po, hindi niya dapat binunot o sinira ang wire. That would involve also a case of malicious mischief, criminal case din yan. Kasi dapat yung nag-relocation survey na genetic engineer, ang gagawin lang po niya is maglalagay siya ng kanyang sariling mohon. Na ito ang nangyari sa aking relocation survey per my certification at per my plan, the relocation plan that I did, itong findings ko, at naglagay po ako ng bagong mohon. Na yung mohon ay hindi pwede tanggalin ng kahit sino. Yan po, na hindi dapat binunot at pinalitan, hindi po. Hindi po pwede yan. So, in that particular case, you have to go to a lawyer now, Sylvia, and file a case, no? For that matter, no? So, isang guni po nyo sa abogado inyong problema dahil medyo technical and delikado na po ito, and you present all the facts, no? And evidences and proof that you have, no? To that particular lawyer so that he will assess it and file a case against the perpetrators. Okay? So, based on your question, it would appear na yung pagtanggal ng mohon is not allowed under the law. One spaces, attorney, pwede po ba i-file ang kaso sa Pasig where the heirs resides but the disputed land with possible forgery is located outside Manila. Okay, depende po. Ano ba ang pinag-awayan? Ang pag-recover sa property or ang forgery? Now, forgery kasi, if it was committed in where the crime was committed, no? So, saan po niya pinorge? So, pinorge po niya doon sa, let's say, sa Manila. Doon siya nag-forge. So, it was there that the crime was committed. However, if that document was used to get the property and in another place, tapos nagkaroon siya ng misappropriations ng funds and everything, by the use of that falsified document, there might be estafa or there might be theft. Huh? So, therefore, ang crime naman na commit, doon na po kung saan nangyari. Ibig sabihin po, where the crime is committed, that is where you file a case. Okay? But if what you're filing is for the recovery of possession of the property on the ground that forge ang signature, dapat ibalik yan sa akin, then you have to file where the property is located. Now, if you file a case for damages for forging your signature, civil case for damages, without filing a criminal case or recovery of possession of property and everything, danyos perwisyo lang, then you could file where you reside or where the defendant resides at your option. So, depende po, no? Depende po yung venue, depende po sa i-ask natin or if-file natin na kaso. Magdedepende po yan. So, in that particular case, you have to secure the services of a lawyer to consult, no? And present your side kung ano ba talagang pinakamainam na game plan na gagawin. Ano ba talaga ang gusto mo because of that falsified or forged signature. Yung forgery, ano ba talaga ang purpose natin? So, if our purpose has different intents, no? Then therefore, depende kung saan ang venue. Okay? I hope you got my point, no? So, si Sol Sanchez, okay. Si Sol Sanchez, sabi niya, magandang hapon, attorney. Ano po ang mga steps mag-apply ng amnesty sa estate tax? Saan po ba magpa-compute kung magkano babayaran at ano po ang requirements sa pag-apply nito? Well, Sol Sanchez is number one, is meron silang BIR form for the application of tax amnesty. Now, hindi ko po muna diniscuss sa ating video lecture because I am waiting for the implementing rules. Wala pa kasi implementing rules para isahan na sana ba? Kasi I could use the Revenue Memorandum Circular in 2019, no, for that second amnesty, which is actually what we are using right now na paggamit. Because sabi kasi ng batas, no, that the estate tax amnesty shall be effective with or without the implementing rules by the BIR. So, ginagamit po namin yung 2019 Revenue Memorandum Circular wherein we used, no, may form po sila for estate tax amnesty application and they will give you a computation. Parang order of payment, no? And from there, mga requirements nila is nag-require sila ng extrajudicial settlement, tapos yung mga TIN certification. Hindi na po TIN verification ngayon. TIN certification, no? It is a piece, I don't know if that's being followed everywhere in the Philippines, but in Davao City, they issue a certification that is, I think, valid for 1 year or 3 years, wherein it certifies that yan ang tax identification number ng payer. At saka kailangan po ng TIN din, kunin yung estate, no? So, yung mga affidavit of no improvement or certificate of no improvement and certificate of no improvement kung walang improvement sa property. So, yun po, no? Those are the things, no, that you have to submit, no? Because that is what we call an extrajudicial settlement wherein all the heirs cooperated. Hindi lang po mag-e-effect yung rule, I believe, no? Yung tinatawag nating if hindi nagko-cooperate yung heirs and what the heir wants to pay, para at least lang man makahabol sa estate tax. Saka na lang yung pag-transfer ng property or mag-cooperate na sila for the signing of the AGS. Kaya sabi natin, separate and distinct process na po ang pagbayad at yung pag-transfer. So, having said that, yung rule for that matter, yun ang inantay ko na circular ng BIR. Now, I believe that the circular will come out this week. pinaka-last po siguro next week. You know why? Because naglapse na rin yung 30 days period nila within which to make a circular. Kinount ko yan eh. Naglapse sila ngayon by next week. So I hope it will come out by next week. September 10, no? September 10, yeah. 15 yata ang deadline nila or 14. So malamang baka before that deadline, lalabas na next week or next week. Alright, take note of that. Sir Merlita Arellano, attorney, I'm just wondering kung bakit na may mga kamag-anak na wala kayong luok, hindi kundi ang sariling kamag-anak din. Wala kayang lokohin. Ano ba yun? I'm just wondering kung bakit na may mga kamag-anak na walang kayang lokohin kundi ang sariling kamag-anak. Well, because of the thinking that they will not be held criminally liable. Kaya nga naman, pinsan mo, nakawan ka or takbuhan ka ng pera, mangyari lang yan. Karamihan, no? About 80%. Sige, hayaan mo na lang, pinsan eh. Anak ng kapatid ng papa ko yan. Tingnan, pinsan eh. Pero hindi na siya makakalapit sa akin, alam mo yan, yung mga ganyang klaseng ugali ba? Kaya sila, they would tend to cheat, no? Their relatives. Ako, I would tell you, frankly, I've been cheated for quite a time. By some, no? Hindi naman lahat. Some of my relatives, hindi na ako nababayar. Okay na lang. Yeah, mag-anak eh. Hindi na ako nag-file ng collection suit. Alright, so, yeah, that's how, that irony, they tend to tinatapakan yung mga kamag-anak dahil alam nilang hindi sila papailan ng kaso. They feel that they will do that. No? Okay, Samson Yu. May for sale po na 10 hektarya na agricultural land. Sabi po ng heirs ay mabibigyan ng dark clearance dahil 3 classifications. Rice, bamboo, at pasture of pasture of less than 5 hectares each. Kahit 1 lang ang buyer. Pwede po ba? Hindi po, may 5 ano po, no? 5 hectares limitation lang po tayo, no? For a dark clearance, no? Siguro, ang ginamin niya is that bibiakin itong 10 hectares. But, ito ang ino-worry ko. Itong rice, bamboo, well, I agree. It's an irrigated, depende, no? Irrigated ba na rice land? Hindi convertible yan. Pero it can be sold, no? Bamboo, yes. Ito pasture ba? Baka kasi itong ginamin niya, halo siya. Baka hindi ito titled lahat, Samson. Baka kasi hindi titled lahat kasi baka may pasture lease agreement lang with the DNR, no? So, depende, no? I would love to also see again that particular document para mapag-aralan natin mabuti. Si Hazel Ice. Oh, good afternoon, Hazel. Good afternoon din po daw sa lahat, sabi niya. Okay. Merlita, attorney, what I know na ang lahat ng lupain sa Mindanao ay titled na since 1960. Bakit 2000 meron pa nakakapag-title ng original title, no? O OCT? Alam nyo, when there was a law enacted by, there's a presidential decree signed by the former President Marcos. I could not remember if it was in 1960 or 1976. I had already a video lecture on that. Wherein binibigyan niya ng 3 months, or 6 months yata yun, wherein all titles under Spanish claim, which has not been registered with the Torrens title, shall be registered. Otherwise, it becomes goes back to the government and will be classified later on as alienable and disposable. Marami pong mga properties dito sa Mindanao, even sa Davao City, na Spanish title po. Now, maraming nagkakagulo kasi may Spanish title nga. Then they're claiming that they own this whole block of property. Well, ang rule kasi is that, sige, If that is true, that's Spanish title. Get a certified true copy from LRA kung lalabas ba. Pag lumabas, ibig sabihin na restro nila sa torrent system under that presidential decree ni President Marcos, former president, no? Otherwise, kung wala, ibig sabihin hindi nila napa-register sa torrent system and therefore void na po yun. And lahat ng lupa na covered doon, nag-revert back sa government to be further classified. And later on nga, na-classify siya as alienable and disposable. Kapag alam natin, pag alienable and disposable, pwede na po applyan sa DNR for patent. Okay? That is the explanation of that. Maayong hapon, Attorney Per-Am. Magandang hapon din po, Per-Am. And si Success Aura. Attorney, si Lolo ay may isang anak at apo. Okay. Isa lang anak niya at apo, ha? Ang anak, married 1993. Gusto po ni Lolo ang apo at anak ang tagapagmana. Gusto po ni Lolo na hindi mapunta sa manugang at illegitimate anak ng manugang. Oh, yes. In case mawala po si Lolo at anak niya, pwede na po niyang gawan ng last will and testament, no? Na this will go to the anak niya at sa kanyang apo na kadugo niya. I think gusto niya ma-reserve sa bloodline. Tama ba ako, Success, Aura? Gusto niya ma-reserve sa bloodline. Pwede po siya magawa ng last will and testament. However, suppose namatay si Lolo, walang last will and testament, at buhay pa si anak at si apo. Question, sino po ang tagapagmana? And the answer is, si anak lang. And that would be considered as exclusive property. Kahit married siya sa manugang na sinasabi mo. Na wala magawa si manugang kung sakaling si anak ibigay niya ibigay niya rin sa anak niya. Or later on, ibenta niya kahit at any time without the consent of the manugang. Bakit? Exclusive nga niya eh. Diba sabi ko sa inyo, anything that acquired during the marriage is exclusive property by the inheritor or by the grantee in case of deed of donation. Gratuitous transfer, gratis, libre, natanggap mo sa panahon na may asawa ka. Whether galing sa ninuno mo, kamag-anak mo, or sa stranger. Basta gratis po. Pag binigay sa inyo, libre po. Ibig sabihin niyan, that is an exclusive property. Walang pakialam ang asawa mo. Even if nailagay sa title na married to. The married to is only a description that that particular person is married to the real owner, the exclusive owner. Okay. So, ibig sabihin, pwede niyang benta. Habang buhay siya, anything that he could do, pwede niya donate, last will lang kanino niya gusto ibigay. Because that is exclusive property. Okay? Without need ng consent ng asawa. Because hindi nga conjugal property yan. The only exception lang na mangyayari is kapag naunang namatay, yun siya, yung exclusive owner ng property. Yung anak ni Lolo. At naiwan ngayon si manugang ni Lolo. Na ayaw niya. That case, compulsory heir under the law. Magkakaroon siya ng 1 share on that property together with the anak nila. Wala pa rin kasali yung illegitimate ng manugang. Ha? Hindi pa rin siya kasali. Mag-share siya together sa anak. Okay? Then, may ownership rights na yung manugang na ayaw ni Lolo. Now, in case that manugang dies, yung illegitimate niya, magmamana ngayon. Yun po mahahaluan. So, pray lang natin na si anak ni Lolo, yung totoong anak niya na tatanggap ng property, hindi maunang mamatay doon sa manugang na ayaw, no? Para hindi po mabahira, no? Dapat pag benta na agad niya. O lipat niya sa pangalan kaagad ng kanyang anak. No? Pwede po yun. Waive niya kagad lahat para directly. Kasi yung illegitimate child ng asawa niya, hindi man magmamana doon sa kanyang parang foster sister. Ano ang tawag yan? Parang step brother or step sister. Diba? Kasi hindi man sila half brother niya, hindi man sila magmamana doon. So, yeah. Ganun po ang dapat gagawin. Okay? One spaces, attorney, pag nag-umpisa po ang forgery of fraud sa isang notary public, from a legal instrument at ginamit po transfer properties of heirs to her relatives, nailipat po talaga. Sino po kasuhan? Ay, lahat na kasuhan mo. Usually, ang ginagawa ng ibang lawyers, talagang kasuhan ang lahat and let the fiscal determine kung sino ititira. Sino yung isasalit, sino hindi. But nevertheless, if I see, ang notary public, baka walang alam. Baka alam lang ng notary public, basta pirma kasi mga pirmatologists ang tawag namin yan. Yung ganing kahit walang appearance, personal appearance, pirma. So, hindi niya ma-determine kung forged Indian document, no? Now, the document becomes a defective instrument. It is no longer a public instrument. Now, becomes a private instrument. Now, kung deed of donation, void siya. Pag sale, it's a private instrument, private writing. So, by forgery, yung pilan mo yung kaso, sino yung nag-forge? At sino yung nakatanggap ng benefit noon? So, kung inailipat po at alam ng relatives na forge yun, then nag-benefit sila doon. Therefore, pwede pong bawiin sa kanila. But, mahirapan tayo sa forgery, no? Unless kasi, ang forgery kasi yung author talaga. At yung may nakakalaman, yung in conspiracy ba? So, case-to-case basis po yun. Depende po sa senaryo. Ano mangyayari doon sa abogado? Kung talagang galit na galit kayo at Thailand yung administrative action, baka matanggalan ng lisensya. So, yun lang po. No? Kasi nga, ang point namin ngayon, ang clamor namin ngayon sa IBP is that as much as possible, kung to perform the duties as a notary public pa, hindi man ako nagmamalinis. There are instances that I also commit mistake, no, in my performance as a notary public. Na kakamali. But what I'm trying to say is that yung talagang notorious na notary public na kahit nakapikit ang mata, pirma lang ng pirma, hindi na po pwedeng ganun. I mean, ang trabaho po namin is to determine, no? Sir, ma'am, kayo po ba ito? Okay, sana pong ID nyo? Titingnan namin ang mukha sa picture. Ikaw pala ito. Ang pirma nila, parehas ba? So, naintindihan po ba yung pinirmahan ninyo? Ito po is waiver po ito or donation po ito or sale po ito. Yes, sir, naintindihan pa. Ito ang presyo and everything. Okay, naintindihan? Go, okay? Pirma lahat. Yan, sarapan ko. Pirmahan yung libro ko. Yan man dapat, no? When it comes to transmission of rights and or waiver of rights, no, yung paglipat ng karapatan from one person to another, karapatan sa pagmamayari, karapatan sa pagpossession, karapatan sa paggamit, no? Yung bundle of rights ba, yung possession, ownership and everything, ililipat mo sa iba. Careful talaga tayo sa notarization yan. Kasi konting mali po, magiging defective notarization by the notary public. That's why, ang advice ko talaga is to go to a legitimate notary public and demand from the notary public the necessary protocols. Pag hindi niya nagawa na i-interview, sir, ito po yung heirs, ito po yung IDs namin, could you check? You have to get it, no? You have to put that in your book and we have to sign on the book to show that we are here. That is ng abogado na you mean business. You want to put down everything. Pag sabi niya, ay, hindi na, awag na. Manglipat ka na ibang abogado pag gano'n. Alam mo, ang pinaka-stricto ng mga notary public ngayon is yung mga bago. They're very strict, no? Talagang personal appearance and everything, no? Yung super grabe na matatanda na siya sa old rules ba? Wala. I mean, sometimes yun sila ang nagbabiolate, Marami po, no? So be careful lang po tayo. Yung mga barker dyan sa tabi-tabi sa bangketa, wag po kayo maniwala dyan. Notaryo dito, 200 lang. Paglapit mo, sir, panotarize ako. So sige, antay ka lang dyan, ha? Notarihin ko. Yung pala, meron na siyang tatak niya sarili, peke pala. Bigay sa'yo, bayad ka rin. May selyo and everything. Pag transfer mo, it appears from the documents, it's clear. But somebody questions it at maungkat at talagang ma-detect talaga na fake yun, wala. Kawawa ka. Sa pagbili ng property or sa pag-transact mo, grabe ang due diligence mo and gastos mo sa lahat ng effort mo so to be perfect na walang palpak. Tapos sa huli, dahil magpapirma na sa abogado, doon ka pa magkuripot, sabihin mo, dito lang tayo, tag 500, tag 200. Di ba? So, hindi naman sinasabing ang pag-charge is unreasonable, no? May mga reasonable lawyers din, no? There are others who charge only sa deed of sale ng, let's say, 2% per their professional fee and notarization. Iba, 3%. The higher it is, the lower the percentage. Usually, mga ganun. Nakakausap naman sila ng matino, no? So, ganun lang, no? It's how you conduct your business to the notary properly. Evelyn Dancel, good afternoon, Attorney Batu. Watching from Montalban, Rizal. Salamat po, Evelyn Dancel, ha? Kumusta? And my idol, si John Paul de Villeres. Hindi ko na po sabihin kung sino po itong idol ko. I love this guy. And I would say that he's my idol public officer. No, mabilis po magtrabaho. Okay? Gusto niyo malaman kung sino siya? I-search niyo na lang sa Google. Mabilis po ito. Wala ito, hindi ito magkakaproblema sa Artalo. Baka apailan pa niyang kaso yung Arta. Dahil matagal masyado ang binigay na time. Ang bilis ng tao nito magtrabaho. Passion niya to work. Even to bring home, even to work on days na hindi nabayad. Sobra na. These are the kind of people that we should have. Okay, thank you so much. And he is my idol. We call each other idol because we idol each other. Okay, Karen G. Attorney, ask po kung naibenta ang lupa, di pa napakancel yung mortgage and nakatatak sa title or tax deck, maski nabayaran na, may tatransfer po ba sa pangalan na buyer at pwede po yung buyer na lang magpakancel? Yes po. May lilipat po yan sa buyer. Magke-carry over lang po yung annotation of mortgage. Now, kung meron po kayong cancellation of mortgage, yung recent cancellation of mortgage, notarized na yun, no? Sabay nyo na po, no? Ipasok mo na yun sa entry, tapos sabay na yung sale. Para paglabas ng title, bagong title, tapos may cancellation na rin ng real estate mortgage. Yun naman important. May ibang bayad doon, ha, sa cancellation. Iba rin yung bayad sa subsequent registration sa Registry of Deeds, no? But nevertheless, isabay na lang, no? Pwede pong si buyer na po ang gumawa niyan. Basta importante po, meron po kayong recent cancellation of mortgage sa napag-utangan. Duly signed and notarized, may ID po, kompleto po. No, klaro po talagang nabayaran, ha? Baka naman peke yung release and cancellation of mortgage. So, you better be sure to deal with properly, no? To ask if, kung pwede nga makausap yung napag-utangan yung magbigay ng release and cancellation of mortgage, mas better. Di ba? Para hindi po tayo mapalpak, Haron. Okay, Haron G, our friend here, no? Once basis, attorney, lalo na ho, patay na ho ang nagnotaryo pero present pa ang mga may hawak ng pre-patent title. Well, kung patay na po yung nung nagnotaryo, well, wala na tayo magkama, no? It carries with him the sins that he committed, no? In his grave, no? But still, it doesn't mean that you could not question the document. No? You could still question the document. Kung may hawak doon ng pre-patent title, sila po ang nag-benefit, sila po ang nag-forge and everything, then you could file an action for reconveyance po. No? May yan ang mga procedure. But nevertheless, sabi ko nga, one, you have to go to a notary, to the lawyer, no, to discuss your problem. Kasi iba yung mga facts na binibigay po ninyo, specifics, no, which we need para po mabigyan po natin ng proper solution. Okay. Good day, Attorney Batu. Present po ako. Yes, P. I know you're always present. Nandiyan ka lang naman. Thank you so much, P, ha. Salamat. Sabi ni Merlita, Attorney, sa pag-transfer ng mga heirs ng mana, ano-ano ang system? You explained that Sunday according to the system. Do you think the heirs can do all those things? How about those heirs that no read, no write? Attorney, sa pag-transfer ng mga heirs ng mana, ano-ano ang system? Ano yung sabihin ng system? You explained last Sunday according to the system. Pag-transfer ng mga heirs ng mana, well, you execute an extrajudicial settlement. And yun po ang sistema. Everybody signs, no? Now, do you think the heirs can do all those things? How about those heirs that no read, no write? They could affix their thumb mark. Kaya nga nandito sa aming mga abogado, ako, no? Pag hindi no read, no write yung pipirma, meron kaming rules sa notarial law is that aside from the thumb mark, no, sa baba noon may nakatatak yun, witness to thumb mark. That the thumb mark was affixed in the presence of two disinterested witness and in the presence of the notary public. Ibig sabihin, may titingin talaga sa pag-thumb mark niya na dalawang witness, nilalagay ang pangalan nila, pirmahan, at saka address. Nandiyan po yan sa rules of notary. Ako meron akong stamp pinagawa niyan para pag thumb mark lang sir, kaya hindi ako marunong magpirma. Thumb mark niya, ako tatakan ko agad witnesses. I will not get my witness doon sa opisina. I let him bring two witnesses that could identify that person really doesn't know how to sign his signature. to affix his signature. But of course, I will be asking his valid identification. Makikita mo na sa valid ID niya, puro nakatammark din siya. Titingnan ko rin yung picture niya kung siya ba talaga ito. Tapos tatanungin ko siya. Pinaka-importanting gagawin ko before siya mag-tammark, naiintindihan mo ba ang English? Hindi po. Makabasa ka ba? Hindi po. Hindi po ako makasulat. Hindi po ako marunong magpirma. Kundi tammark lang. Okay, explain ko sa iyo. Ito pong pipirmahan niyo po, ito po yung minana niyo sa magulang niyo na ngayon ay paghahatian ninyong na magkakapatid. Okay po, alam ko po yan. Tapos ngayon, nakasaad dito na itong parte mo, idodonate mo doon sa kapatid mo kanya na para wala ka na. Ay, hindi ko alam yan, sir. Nangyari niyan. Ang sabi, hatiin lang namin, bakit ko ibigay sa kanya? Akin yan, ayan na. So, you know, the role of a notary public is very important. You talk to them na ganito. At least malaman lang. Now, kung alam talagang, meron talagang waiver, ay, yes, sir, okay lang po, talagang kanya yan, ganun. Di alam, maintindihan, no? Intindihan niya. Explain mo ng mabuti. Explain namin ng mabuti yan. O, sige, ha, sure ka na, naintindihan mo ito, ha? Wala talagang pag-alinlangan, ha? Okay. Tammark. Okay. Pati sa libro ko, tammark ka. Yan. Yun ang nangyayari dyan. Now, tandaan po ninyo, ha? Ano po ba ang technique para malaman nyo kapag ang tao ay hindi marunong magbasa? Sabi niya, hindi po ako marunong magbasa, sir. Ah, ganun ba? Babasahin mo, hindi talaga. Ay, hindi ko alam yan, sir. Kahit Tagalog pa yun, English, hindi ako marunong yan, sir. Ah, ganun. Sabihin mo, sige, pakisulat daw ng ano be, ng pangalan mo. Ano ba pangalan mo? Raymond Batu? Or Merlita Arellano? Sige, sulat. Pag marunong pong magsulat, ibig sabihin po, marunong yan magbasa. That is the rule. So, ay sir, marunong po kayo magbasa. Bakit po? Marunong kayo magsulat eh. Yan po. Yan po ang rule, ha? Take note of that. Yan ang technique. Okay. Claudio Bitoy. Good afternoon, Attorney Batu. Nagtatanong lang po ako kung may karapatan na ba yung mga anak na siyang nag-improve ng area na wala pang extrajudicial settlement sa 4 na kapatid ko. Ganito po yan, no? May property. Namatay ang parents. May mga kapatid, 5 sila. By operation of law. Kaya nga, sa deathbed, di ba, pag mamatay, hospital, sabihin pa ng doctor, time of death, 5:30. September 10, 2023. From that moment, it was declared dead disease. Yung 5 pong anak, by operation of law, automatic sila na po ang may-ari nun. They are considered as forced co-owners. They're considered as forced heirs. Co-heirs. Okay. Ibig sabihin, yung property niyan, anything that will be done in that property, to sell, to develop, to lease, to mortgage, everything, it needs the consent of everyone. If one of them do something to the property without the consent of the other property, that property may be pwedeng tanggalin, sirain. Because you cannot do that. You cannot improve something without the consent of the other. And you cannot even claim dahil gumastos ako, babayaran niyo ako. No. In the first place, you did not get our consent. Tandaan po natin yan, no? Kasi lahat po ng bagay na gagawin sa lupa na yan, kahit po sabihin nating maghukay ka lang ng balon, bawal po kung hindi ka magpaalam. Kasi hindi pa nada-divide eh. Hindi pa nalalaman kung saan ang area mo dyan. Kaya nga, ang next step is to partition. Kapag ang property is divisible, pwede i-divide, edi biak-biakin, paghatian nyo. Pag indivisible, hindi pwedeng i-divide, ibenta at ang pera ang paghahatian. Yan ang rule. Merong property, from the word divisible and indivisible, klaro lang, hindi ma-divide. Like example, isang kakapiranggot na lupa na 100 square meters, may bahay doon, 5 ang maghahati nun, pwede ba yun siya i-divide ang 100 square meters na may bahay? Of course, indivisible yan. In order to have it partition, ibebenta yan. Sasabihin ng judge, benta yan. Kung hindi ka nagkaintindihan, ibenta yan. Tapos, proceeds pagkatian nyo divided by 5. under the Civil Code 636, if I could remember right, no co-owner may be forced to stay in the co-ownership. Pwede niyang i-request ang partition. Whether indivisible or divisible. May ibang property, yung katulad ng 1 hectare land. So, klaro naman, patag, pwede namang i-divide, no problem. Tag 2,000 square meters sila. So, ang gagawin niyan is mag-hire ng geodetic engineer and gawa ng subdivision survey. Lot 1, lot 2, lot 3, lot 4, lot 5. Okay, let's say 5. Mag-usapan, pwede bang akin to? 1, 2. Sige, may mga kapatid. Sige, sa'yo na yan. 2, 3, sa'yo akin yan. Ganun. May iba naman, ay mag-raffle tayo. Tambiolo tayo or bunot-bunot. Ganun. And once they bunot-bunot, so, okay, sa'yo ang lot 1, ha? Pwede na ba yung ganun? Hindi pa. Kailangan po natin gumawa ng partition agreement. Lapit na naman tayo sa abogado. Sir, ito po nag-usapan namin. Pinasurvey namin to. Approved na ng Bureau of Plans, Land Management Services, and may technical description na ito po napag-usapan namin. Gawa po kami ng partition agreement. Beda ba yung estate niya ng tatay niya? Ay, hindi pa po. Ay, extrajudicial settlement and partition po ang gagawin natin yan. Sabihin ng abogado. Dahil babayaran yung estate tax, the same time, i-partition nyo yan. Meron po bang tax consequence ang partition? Wala po. Kasi equal man ang division. So, it's a consequence of ownership na naghiwalay lang kayo. Bayad ka lang sa Registry of Deeds para ma-subdivide yan. Di ba? Kasi magpapile kayo ng petition for splitting of title. Merong corresponding fee. I-issuean kayo ng iba-ibang title yan. Okay? And you have to pay the estate tax para ma-transfer din. Okay? So, malayo na tayo. So, ang ibig ko sabihin, divisible or indivisible. But I would like to discuss now to you, my friends, that there is a kind of indivisible property even if from the face itself, from the location or the area itself, it appears to be indivisible. Sabi ng Supreme Court, indivisible pa rin siya. Kunyari, 1 hektarya ng lupa. Okay? The truth is, if we divide it at 2,000, pwede naman. Pero sabi ng Supreme Court, kapag mag-diminish ang value ng property dahil sa gagawing pag-divide, indivisible po yan. Ano po ang example ko? 1 hectare property nga, tabi ng dagat. Pero, rectangular. Yung dulo ng rectangle, yun ang nakaharap sa dagat. Now, everyone ng kapatid na 5, gusto nila na nakaharap sa dagat. Diba? So, ang pag-divide din, rectangular na panipis. So, tuloy na maliit. Now, suppose that will be subdivided and agreed. Pwede man. Talaga. The question is, tataas bang value niyan o lumiit? Mag-diminish ang value. Sino ba naman bibili na ang frontage kaliit-liit tapos pahaba pa dulong doon, papunta doon? Di ba? So, that is the rule of indivisible siya, pero sabi ng Supreme Court, indivisible because when the value of that property decreases if there is an intent to subdivide it. Okay, or if the division will be undertaken. Okay, take note of that, ha? Guys, ha? Hindi lahat para dagdag kaalaman yan. Pamilya. Attorney, kapag nasa Australia si husband, pwede ba siya magpagawa ng affidavit na wala siyang pinipirmahan na deed of sale para manalify yung ginawang sale ng wife niya na namatay na para ma-process na ng anak? Well, kung totoo po na wala siyang pinirmahan, no? He can execute an affidavit and he could go to the consular office. If not, kung mas malapit doon sa DFA ng US, kung malayo yung consul's office ng Philippine Consul or embassy, ipa-apostille. Basta as long as the country is member of the Apostille Convention. And that would be maybe used as an evidence in court, as a public document. You can present that in court without need of the introduction of proof as its genuineness and execution. Kasi ang rule is that it is presumed to be regular and it's a public document. However, as to its probative value or evidentiary value, walang wala, hindi magagamit yun kung ang nag-execute ng affidavit ay hindi magte-testify in court. Hearsay yun eh. Even if it is in public document. Matatanggap ng korte. Pero ang probative value niya or yung evidentiary value niya or yung value niya bilang ebidensya, walang value. Kaya kailangan you have to testify what is stated there. Otherwise, if there is no need to testify, kadali na lang pala maggawa ng storya lang, no, na hindi ako nagpirma. The court would want to hear if really that is true. We'll cross-examine. The court may ask questions. The opposing counsel will ask questions kung totoo ba ito sinasabi mo. Baka nagsisinungaling ka rin. Okay? That is the rule. Jack Magante. Magandang hapon, attorney. Tanong ko lang po about sa land conversion po. About sa irrigable area must not be converted to other use. Paano po pag ang lupa na subdivide na tapos titled na yung mga lote na tag 200 square meters? Ang sagot dyan, Jack Magante, yan po ay rollots. And delikado po yan. Ang suggestion ko, wag pong bumili niyan. Number 1, yung pong property po na irrigated area, mga laban ng rice, no? No po yan na pwedeng i-convert into residential. Kaya kapag ang may-ari niyan isinabdivide niya, nilote-lote niyan, may benta. So ito ang bibili niyo ng 200, ipapa-convert ko ito, ipapa-approve ko ito. Kahit pala yan pa yan nakita niyo ngayon, pero dyan po ang future niyo na bahay. Technique nila. Hindi po mangyayari yan. Hindi po kayo kahit na biyak-biyak na pwede, hindi matatransfer ang title sa inyo. Hindi po yan matitirahan. Hindi po ba pagbigyan ng building permit, hindi po tayo magiging residential yan. Wala po makakatira dyan. Bakit po ang rice land, yung irrigable rice land, is no for conversion to residential? Because it aims to protect our food security. Ibig sabihin, kung lahat na lang pala yan ay pwedeng i-convert to residential, di wala na tayong kakainin dahil wala nang mga farmers magtatanim. So, hindi po. No po yan siya. Kaya if you'll notice, yung mga irrigable rice lands right now is the fact that they cannot be converted but their value is very high. Yan po ang dahilan bakit mataas ang mga value ng mga palayan. Even if agricultural sila. So if you want to buy agricultural rice land, you have to utilize that as a rice land. Hindi po yan mako-convert into residential. So take note about that. Take note about it, ha? Take note of that. And Jemlyn de los Reyes, attorney, patay na po ang nanay at tatay namin at ibinenta na kapatid namin ang property ng tatay namin, walang ages. Gusto ko pabulin, payuhan niyo po ako. Magsangguni po kayo sa abogado, pero at this point lang sabihin ko sa inyo, hindi niya pwede nga ibenta. Kasi nga, walang consent ninyo at wala pang AGS. Sino namang tanga na bumili noon? Na alam niyang walang pirma na mga kapatid. Di ba? Baka sinabi mong binibenta pa o binenta. Yung buyer noon will never be considered as a buyer in good faith. No? Ibig sabihin, kahit napatituluhan pa, kahit nalipat yung title sa kanya or naano pa niya, hindi po magiging valid ang ownership niya doon. Okay? Sanggunin niyo po si isang abogado para po matulungan kayo ng lubusan. Si Oni, good PM attorney, magkaiba po ang posisyon ng actual survey ng estate at ng cadastral survey. Ano po ang dapat gawin? Sometimes kasi nagkakamali talaga, no? Kasi sa cadastral survey, long time ago. Then, pag actual survey, pero alam mo, ang susundin talaga, kung ano po yung na-approve plan na nasa DNR, yun po ang susundin eh. Hindi mo po pwede mapakancel ang mga approved plan na nasa, lalo na pag-cadastral, no? So, ano po ibig sabihin ng actual survey? Inactual mo ang posisyon ng bahay mo? Ay, hindi yan pwede. Dapat sundin mo ang cadastral survey. And from there, kung naka-encroach ka, nagkamali ang pagposisyon ng building, talagang dapat magbubalik ka or pasok ka lang dapat sa area na dapat yun ang area mo. Follow-up attorney, si Severino, patay na yung parents na may-ari ng properties pero wala pang AGS among heirs. Okay. So, ano ang question natin, Severino? Si Janet Onreas, attorney, afternoon po from Taiwan. Ask ko lang po, nabili ko Coco Land ng lolo ko. Matagal na may pirmahan sa barangay. Sila magkakapatid. Ngayon, gusto nila bawiin ang property dahil sa kanila po daw yun, no papers po. Kung nabili po ninyong coconut land ng lolo ninyo at may pinirmahan po kayo ng pagbenta noon sa barangay, ang tanong ko po, ang nagbenta po ba sa inyo ang mga heirs ng lolo mo? Ibig sabihin, mga uncles mo. Lahat ba sila? Kasi pag lahat po sila pumirma sa barangay, ibig sabihin, there is a sale. And when you give money and receive nila, consummated na yun. Lalo pag naparesibuhan yung pag-acknowledgement receipt sa pera na nabayad mo. So make sure Janet, that everybody has signed. No? Walang isa na hindi nakapirma. Kasi pag may isang hindi nakapirma, sabi ko sa inyo, hindi valid ang transaction. Kasi conjugal nga conjugal, co-ownership nga sila lahat Okay? Take note of that. Kaya nga, very careful tayo kapag bibilihin natin galing sa mana. We have to determine all the heirs. We have to determine who are these people para hindi tayo mapalpak, no? At least, exercise tayo ng extraordinary diligence of a good father of the family. Hindi lang kay normal diligence, extraordinary diligence po ang suggestion ko. Pwedeng hingian mo lahat sila ng birth certificate. Makikita mo ang in order doon kung pang ilang anak sila. Makikita man doon, bilangan. Okay? So take note of that. Sabi ni P, ask ko lang po, yung kapatid ko, tumayo na attorney in fact sa parents ko. Both stroke na po. As in, bed arrest na po sila for issuance of new title. Duplicate po. But before that po, alam na naming pareho-pareho po. The attorney in fact ninyo ang stroke para mag-issue ng new title. So, pinapirma ninyo. Siguro kayo na lang humawak sa kamay para pirma ng tatay niya. Tapos alam niyo lahat and you consented on it. Gusto niyo lang lumabas yung new title duplicate. Well, technically speaking, if the lawyer will notarize that will do it, malaki ang delikado, no? Kasi nga, trabaho namin, we really have to investigate. Now, kung stroke na, hindi niya naintindihan ang pirma niya, so, incapable to give consent, malamang voidable on document, no? Pero anyway, ang rule naman kasi, if nobody complains, kaya sabi mo lahat kayo, alam niyo naman, okay lang. Nobody complains, nobody knows, nobody everything, then, it's possible na makakuha kayo ng new title. If the judge says, kasi, pag, ang SPA kasi, notaryado kasi, kahit mark pa and everything, it will have that resemblance of a duly executed document. It becomes a public document. Unless, presumption nga regular. Unless there is someone who will contest it that it is irregular or defective. If there is none, it will continue to become a valid document. And therefore, the court may pass judgment and will redirect the registry of deeds to issue a new title replacing the lost one. Yun ang sagot ko dyan, P. Okay, si Labial Juby. Tapos mag-successful po ba yung AGS na di po agree ang isang years gusto lang mangyari at di po siya pumirma? Okay, si MB. Good afternoon, Attorney Batu. Do illegitimate children have the right to inherit family home? As of time of death of my father, 1999, the wife and the legitimate children are alive. Well, actually, hindi kasi ang mind kasi natin pag ma-inherit tayo, kapag marami tayong kasama sa inheritance kasi, we inherit sa share. Meron tayong intestate share sa estate ng deceased. Now, if the family home is one of these property that would be considered as part si illegitimate child. Dahil meron mang one-half share doon si husband na namatay, di ba? And illegitimate child recognized, acknowledged. But it doesn't mean kasi specifically natitira siya doon. It is possible na meron siyang share doon at pwede namang pag-usapan na can we buy you out for this? So that ang value nito ganito, then we buy you out para kami lang din doon. Pwede ganun. Or kung hindi talaga makaintindihan, that family home will be sold. And the proceeds thereof divided by. Paano ang division? Kasi conjugal property yan eh. 50% lang ang pag-uusapan natin. Yung other 50% ng house, sa surviving spouse yan. So, sino ang may-ari ng remaining 50%? Yung sa estate ng namatay. Of course, one share si wife, one share si legitimate child, and one half of that of an legitimate child ang illegitimate. Kalahati lang kanya. Pag ma-compute po yan, yun lang ang share niya. So, ang karamihan po ang ginagawa, binabuy out na lang sila. So, ibig sabihin, extrajudicial settlement with sale of intestate share with respect to this particular property. Pwede man yun. So, merong capital gain tax consequence and doc stamp consequence for that. Yan ang mga style, no? Or sometimes, iba na lang, o sige, in consideration na mag-waive ka dito, mag-waive din kami nung isang property para sa'yo na rin. Okay, alam mo, lahat kasi, kaya maganda kasi kung sana sa problem on succession, dapat sana mag-usap lahat, no? Huwag na yung issue na palangga siya ni Papa dahil marami siyang na-benefit nun dahil eldest siya or youngest siya. Ay, illegitimate ka ng asawa ko. Wala akong pakialam siya. Huwag ganun. I mean, you have to be civil and practical, everyone, and talk, no? Because the law is the law, eh. At the end of the day, if somebody insists on his right to enforce the law, wala tayong magagawa, eh. Ganun yun, eh. Might as well, pag-usapan na ngayon, huwag na palalain. And then, negotiate ba? Can we have this and you have this? Kasi po, ang computation po, ganito ang computation sa inyo. Now, based on the value of this property, equivalent na po yan sa share mo as a legitimate child. Do you want to have this? Para amin ito lahat. O sige, gawa ng papeles. Ang bugado nang gagawa niyan. Gawa na yan ng mga diskarte dyan. Basta as long as agreed upon by the parties, no problema. Okay? Take note of that. Okay, so nasa akin ang title po, minded by my parents. And bago po yan, alam niya na kapatid, meron kaming sumusubari for that particular title. Ano po kayong pwedeng kasus? Okay. Ibig sabihin po, alam nila na ang titulo is nasa isang tao. Tapos nagpa-lost title pa, tapos pinapirma pa. Hindi pwede yun. Ang ginagawa po namin pag meron pong siyempre, mag-execute sila ng affidavit of loss, no? At ipapatak na sa registry of deeds. So, pag alam ninyo nagpa-affidavit of loss sila, hindi pa sila nagkukorte, magpadala kagad magpatatak ka rin ng affidavit stating na hindi nawawala ang title. Ang ginagawa nilang term is affidavit of non-loss. A simple affidavit will do. Affidavit declaring that the title has not been lost. Okay. Ano lang, maganda, no? So, if it is declared as not lost, pag makita ng registry of deeds na nandyan talaga ang original owner's copy of the title, ay registrable yung affidavit of non-loss na yan. I-notate ka agad nila yan. And approve ka agad yan. Wala na Because the registry of deeds is interested also to protect the integrity and sanctity of these titles na hindi pwedeng lukulukuhin lang, just get the court order directing them to execute another one. Kita nila ganyan, in fact nga, ang mga registry of deeds, mandated yan sila kapag mag-present kayo ng title doon, yung pala peke, nila yan, talagang i-confiscate nila. So, ibig sabihin, yung sanctity and integrity of these forms, judicial forms, ito mga title, pinaprotektahan nila. Pag malaman nilang nagloko yung isa na affidavit of loss, tapos yung pala hindi naman pala nawawala at nandiyan pala ang title sa'yo, approve ka agad nila yan yung affidavit of non-loss or affidavit of recovery for that matter. pwede bit of recovery of title. Iba-ibang pangalan, but the same lang po ang tenor niyan na nandyan ang title na owner's copy, hindi nawawala. Now, as to the issue on whether or not you could file a case for perjury, falsification, etc. That's another story. Sangguni po tayo ng abogado niyan. Di ba iba po ang facts kasi, so that would depend. No? Okay? Si Oni, good PM attorney, what government agency po ang mag-classify ng isang municipality kung urban or rural? May issue po kasi sa easement ng estate for subdivision. Sino po ang mag-classify ng municipality urban or rural? Ganda yan ha? Pero ang ginagawa ko lang kasi is that I will just look at the Google, natatype ko, anong klaseng municipality ba ito or city ito, magsabi. Pero I think, hindi ako sure kung sino ang nagka-classify ko. Ang municipality ba ay urban, rural, or first class, second class, third class, fourth class, no? DILG, for that matter. I-search nyo na sa Google, no? Kung sino ang nagka-classify if anong klaseng municipality ito. But I am sure that it is a government, national government agency. Kasi ginagawa natin, Google lang kagad. What kind of city, what classification is double city? First class urban or highly urbanized city. Ayan. Ganyan, mga ganyan ginagawa nila. Manila, ganyan. Third class municipality. Mga ganyan, no? So, i-check nyo po sa Google. Najel Roblox. Hello, good PM po, attorney. Good afternoon. Tanong ko lang po kung saan ang mag-file ng recovery of possession sa recovery of title. May magkaiba ba ang acceptance fee niya? Thank you po, attorney. Alam mo, ito si Najela Place Roblox. Ang totoo niyan is that hindi kasi Najela Place Roblox. Sa anak mo ito na naglalaro ng Roblox, hiniram mo para mag-subscribe ka dito sa channel. And then, kaya nagtatanong ka. Kasi anak ko naglalaro din ng Roblox eh. So, pambata ito. Lagay mo ang pangalan mo. Anong pangalan mo? The truth. I'll answer your question. Recovery of possession and recovery of title. Iba-ibang acceptance fee. Bah, galing ha? Iba kasi, may mga lawyers that what they would, some unscrupulous lawyers that per cause of action, sana buuhin na lang, no? Kasi pwede you could file at the same time, no? Recovery possession means you get back the possession of the property. And recovery of title means you have to get the title, that piece of document, no? That evidence of ownership from that person dahil it compel him to surrender it to you. Kung tingnan mo, magkasama yan eh. Kukunin mo yung lupa, pati at titulo. Bigay sa'yo. Dapat isang acceptance fee lang yan. Medyo taas-taas ng konti, pero hindi iba-iba ang acceptance fee yan. In fact, when you file it, you could file it together sa korte. Sabay na yan yung hinihingi mo na yung mga causes of action mo. Okay? So, but I could not blame if the lawyer will charge 2 acceptance fee. Maybe, what you do is to look for another lawyer and magtanong kayo kung baka iba rin ang kanyang sistema. In my case, I do not do 2 acceptance fee. It should be an acceptance fee for everything. If I will insist of different causes of action, let's say 3-4 causes of action, pati damages and everything, isa lang po yan. Isa lang po yan. No? Okay. Oy, nawala ang signal sa brain. Ay, ganito na lang, Labial Juby. Ano mo ako? PM mo ako sa messenger, ha? Ay, kasi medyo hindi ko nag-mix up na yung mga questions mo, no? Hindi na matagpi-tagpi, hindi ko na masagot. Kaya tinatalunan ko na, hindi ko na binabasa. Kindly message me sa messenger, okay? And I'll try to see it. Si Bridget Rojas, oy, magandang hapon din po, Bridget. Kumusta? And yung recovery of title po is may hearing po ba yun or para magpetisyon lang po sa korte? Kasi ayaw po magpahiram ng mother title yung kamag-anak po. Maghihiring din yan, no? Kasi tatanungin din ng korte, bakit ayaw mo magpahiram ng titulo. Kung mother title ka, kailangan niyang biakid. Maghihiring din po yan. Every time you file a case in court wherein it is adversarial in nature, ibig sabihin adversarial, may kalaban ba? Meron kang i-request sa korte na utusan itong tao na ito na ibigay ang titulo sa akin, hiramin ko. Utusan ang ganito, bayaran ka and everything. These are adversarial cases which the court will require the other party to answer. Magsagot siya. Due process ba? Kailangan pakinggan. No? Kaya nga mayroon ang timbangan natin and a lady of justice, dalawa eh. You will listen which side. No? And you have to present evidence. Kung sino ang mas mabigat, dun po siya mag-decide in favor. Okay? And yung hawak po niya na espada, yun po ang pangtaga niya doon sa nagkamali. Para siya ay magbayad ng danyos perwisyo. Direktahan siya na ibigay mo yan. Titulo niyan, gaya ng tanong mo, Miss Roblox. Okay? So, may hearing po yan. No? Yung mga walang hearing po, yan po yung mga non-adversarial cases. No? Ano ba yung mga non-adversarial cases? Yan bang petition for the replacement of lost title? Non-adversarial ba? Yes. Although, kinagawa naming respondent ang Registry of Deeds, hindi man sila mag-oppose. Bahala ka mag-prove kung wala pa talaga. But if it will be converted into adversarial from non-adversarial kapag may mag-oppose. Kaya, for example, yung kanina ng issue na nawawala, no? Yan dyan lang pala. Danain ay file ng petition sa korte na magte-testify na nalaman mo. Mag-appear ka during the hearing. Your Honor, ano ba itong kaso na ito? Lost title? Hello, nandito ang original title sa akin. Magagalit ang korte doon sa nag-file ng petition. Pwede ka maging oppositor sa petition to oppose the issuance of new title because the title is present. Yung mga ganyan, from non-adversarial biglang naging adversarial. Pwede ka magpresenta ng ebidensya na walang kalaban, biglang mayroon nagkalaban. Kasi kapag ang petition or inakyat mo na kaso sa korte, hindi tama, may pagsisinungaling. Magkakabukuhan yan, delikado ka. And hindi mo makukuha ang hinihingi mo. Kasi the other party will know it and will be required to answer by the court. Kaya nga, ano po ang basic po na dapat yung malaman? When you go to court, you should always come with clean hands. Huwag pong pumunta sa korte na marumiin yung kamay at magsisinungaling po tayo para makuha natin yung isang bagay na hindi naman totoo. Okay? Take note of that. So, si Evelyn Dancel, attorney, patay na po ang lolo ko, 93 years old na nanay ko. Tama po ba na sabihin ng mga kapatid ng nanay ko na wag na bigyan ng mana? Hindi po pwede, no? Succession is a matter of right. The law establishes it. Norms establishes it. Kahit wala pang batas, alam natin na ang property na yan is mapupunta yan sa mga anak. In that case, sabihin dahil matandaan na, yan ang problema ba? Magpa-MA ang tawag niyan. Mukhang abogado. They have their own interpretation. That's not correct. That's not allowed. Okay. Estate tax amnesty, Rick Vidal, wala pa rin ang implementing rules. Pero sabi ko, baka this week or next week, nandiyan na implementing rules sa new estate tax amnesty which covers debt on or before May 31, 2022. Randy Berneza, good day. Kumusta, my friend? From Qatar. And si Imelda Mezayas, hello po, attorney. Blessed Sunday. From Dubai. Yes, Imelda, how are you? And si Eman Espinola, good afternoon, attorney. Paano po pag nagbenta ng lupa at for installment? paano pag magbayad ng capital gain tax? Buo pa rin ba ang bayad or installment rin ang capital gain tax? Sorry Good question kasi. Pero may sumasagi sa utak ko ito, Eman. Take note Baka rollats yung binibili mo Kasi usually pag rollats, installment sale yan Magpo-post yan sila sa Facebook. Cut daw, tagwa 100 ang cut, 150 ang cut, 200 ang cut. Yung pala, rollats. Bawal po yan, baka yan ang binibili mo. Okay, legitimate installment sale is yung ng mga subdivision developers, no? Ayala, mga ganyan. Bili ka ng mga condos, installment sales, mga subdivision lots ng Santa Lucia, yan. Yun ang mga installment. Meron ding iba, private property, individually, bebenta ng installment, okay? I will answer your question through an example based on, let's say, a subdivision lot duly developed by a legitimate developer. Let's say Santa Lucia. Now, pag magbayad ka ng reservation fee at magbayad ka ng parang down payment or reservation fee, actually, bigyan kayo ng 2 years to pay the down payment, yung equity. Then after that, pag-start na yung monthly mo. Ang question, every time po ba na magbayad ka monthly, dapat siging kaltas ng 6%? Di ba? Now, yung contract to sell, which establishes the term of payment from what month to another, every time magbayad ba kayo, kakaltas ba ng tax ng 6%? Supposedly, yes. Kasi, that is already considered as a gain on their part, no? Although, pag legitimate subdivision developer, VAT man sila, no? That's considered already as a gain. The problem is, they do not report that. Usually, they do not report that to the bureau. Ang gulo kasi. Imagine every month silang bayad doon. Paano yan pag determine ngayon? Sa system din, maguguluhan din ng BIR niya, no? So, what they do is that the capital gain tax will be done or be paid upon full payment. Dahil doon yung execution ng deed of sale. Doon nila tatakbo on 30 days, then doon nila i-report sa BIR. Alright? Now, here's the problem. Here comes a developer. At the time of the contract to sell, the value of the property na binili, sa bentahan, no? Market value, 5 million. At sabi ng developer, aside from that, you are required to give equity and you have to pay for this para pang taxes. Taxes, ito po. BIR taxes. Nagde-demand sila ng payment ng taxes na hindi naman din nila babayaran. Now, at the end of the day, kapag fully paid na, may deed of sale, doon na po magbabayad. Pero nabigay mo na nung 5 years ago or 10 years ago yung 5 years ago yung bayad mo sa tax sa kanila. Ngayon pa lang gagamitin. Pag-compute iba na ang zonal valuation, mataas na. Hihingan na naman yung buyer, yung kliyente ng additional kasi nag-iba na yung zonal value. Diyan nagkakagulo. Sana, ang gawin ng developer, di mo na sila mag-demand ng payment ng tax. Dahil hindi pa man nila i-report pa rin sa BIR. Doon na lang dapat sa ending. Ilagay lang sa contract nila that they will assume the payment of tax at the time of execution of the final deed of sale, which shall be computed during that time, and the order of payment given to them, they have to pay it within 5 days from receipt. Parang ganon. Ang iba naman developers, the justification, sabi sa akin, baka hindi kasi magbayad, kunin na namin dati, taguin na namin. Which is true. Kasi baka magka-problema. Pag end of final deed of sale, hindi na sila magbayad ng taxes. Napirma ng deed of sale. Magpe-penalty. Sabi ko, ang problema man yan, isang VAT kayo man na mag-absorb. Yes sir, pero para sa doc stamp, kanila man yan. Oh yes, paano kung ayaw na mabayad? Sabi ko, di bayaran nyo lang ang VAT. Then, kung hindi nila ibayaran doon, hindi sila mag-charge sa penalty. You make it clear in the contract na kung hindi nila bayaran, we will proceed with the payment of the VAT on our end. ikaw na mag-transfer niyan. Tapos kung maglampas ang certain period of time, ikaw na mag-process niyan. Out na kami sa processing. Kasi nga, ang ginagawa rin kasi ng ibang developer, china-charge in advance na yung processing fee, notary fee, and everything. Lahat na. Yun ang sometimes magulo dyan. Okay, so kung based on your question, kung buo pa rin bang bayad, installment na capital, hindi po. No? Supposedly dapat, no? Pero ang gulo kung ganun. So, it's the final deed of sale. Yung consummated sale transaction ang basis ng sale of transfer of real part. Because sabi nga nila, wala pa daw transfer. Pero ang argument ko naman dyan, meron na kasing gain pa konti-konti. Pero sabi naman ng kabila is that hindi naman consummated pa ang gain. Sabi ko, okay. So, yun ang final deed of sale ang basis, no? So, hindi po pwedeng installment. So, yan po ang latest. Hindi latest. Yan ang actually existing, no? Na regulation. Pag huli na attorney, ano pang paraan ng pag-process ng amnesty? Ang tatay namatay 2004, ang nanay 2017. Hindi ba pwedeng gawin na one form? O, pwede naman. You have to apply jointly. And you will be given a form na ilalagay nyo anong estates ang isasettle nyo kay tatay who died in 2004 at kay nanay in 2017. Iko-computein po yan. Although iba-ibang law ang gagamitin. Because ang sabi ng batas is that at the time of death, yung applicable law at the time of death ang susunod. So, anong law? BIR law or National Internal Revenue Code in 2004, yun ang babasihan. At ano yung Internal Revenue Code in 2017, yun din ang babasihan. Okay? So, si Burge, attorney, pwede ba yung first story ng bahay para kay Juan at yung second story ay kay Hana? Paano kaya lupa na kinakatayan nitong bahay? Well, pwede po yan, no? It's not against public policy. They could agree. The parties could agree sa yung taas sa kinababa. Now, with respect to the lot, then they will be co-ownership on the land. Hindi man ma-divide yun kasi up and down man yan. So, with respect to the payment of the real property tax, share and share alike sila. Hati sila sa babayaran. Ganyan lang naman eh. Now, per story, although ang computation ng city assessor sa whole tax declaration ng whole building, buo man yan, divide pa rin kung gaano kalaki yung second floor, gaano kalaki ang first floor. To each his own. Mako-compute naman yan. Okay? So, ganyan lang. Gemlin de los Reyes, second tanong ko po, attorney, di po ba illegal ang pagbenta ng property ng tatay ko nang bayaran ko ang property tax? Naka-name pa rin sa tatay ko at gusto ko po bayaran ang estate tax. Inabangan ko lang po ang update nyo. Di po legal pagbenta ng property ng tatay ko nang bang bayaran ko ang property tax? Naka-name. Binili mo kaya? Meron ka man kayong deed of sale? No problem. Even if nasa pangalan pa niya, baka kasi hindi mo binayaran ang capital gain tax para nga may lipat nga ang tax deck sa pangalan mo. You have to undergo that process. Okay? Take note of that. Attorney, sabi ni Success, may karapatan po ba sa estate ng conjugal property ang illegitimate child ng husband kung sakaling si wife ay maunang mamatay? Hindi po. Kasi kung kanino po siya na illegitimate child, doon po siya mag-i-inherit. Hindi po siya pwede mag-inherit sa asawa ng kanyang illegitimate father. Okay? Doon na po sa illegitimate father niya. Pamilya Lakwachera, ano po ang mangyayari sa hatian ng mga anak? Pala ang ibig ko sabihin, kapag dinonate na ng dad ang share niya sa mga apo, na share ng lupa from namatay, wala na. Kasi na-donate na nga eh. As long as walang impairment sa legitim, ha? Yung hindi inubos lahat para ibigay doon sa mga apo. Kasi may legitim kasi yung compulsory heirs, no? Subject to collation yan. Wala na, basta dinonate na. Basta ang donation was done in public instrument, duly notarized by a legitimate notary public. Gemma Brillantes Bernal, good PM attorney, watching from Abra. Meron po na-execute na AGS and affidavit of undertaking suwana. Ngayon, patay siya at di i-recognize na mga heirs yung documents. Paano kaya matransfer ang tax deck, attorney? Hindi nila i-recognize ng mga heirs, no? Bakit hindi i-recognize ng mga heirs? Kanino ba na ilipat ang property? sa isang tao lang, hindi sa lahat ng mga anak ni Juana. Kung hindi po, ang problem mo number one yan is ang possession issue, no? Baka ayaw nila umalis sa lugar at hindi mabayaran because, pwedeng mabayaran because if they will not recognize verbally, okay lang yan, bahala na sila nga, pero kaya namang isettle ang estate tax doon sa BIR niyan. Kaya hawak mo ng documents duly notarized. Ang problema ang possession. Ayun lang umalis, they will not recognize that AGS is, let's say, with waiver to one person only is valid. Then you have to go to court for determination of the right to occupy the property by filing a case for recovery of possession or to boot them out, no? Pero hindi na yan ejectment, no? Ang mangyari niyan is recovery of possession. Kukorte talaga kayo. Concept Suma. Oh, kumusta? Salamat. Thank you, Concept Suma. Salamat ha. And si Imelda Misayas. Attorney, ask po, anong first step gawin patitulo ng transfer? Kasi deed of sale lang hawak namin. Under name mother ko, patay na 2003. My father last April 24 at hinabiling isaayos sa titulo updated sa familiar tax. Well, kapag luma na po ang inyong deed of sale, basta as long as duly notarized and duly executed by the parties who are all capable to give consent and or to give consent entered properly by the parties, then that is a valid document. However, if you will use that document to transfer the title now, executed in 2003, ang laki po ng penalties po na babayaran ninyo sa BIR because capital gain tax should be paid within 30 days upon the execution of the deed of sale. Whereas a capital gain tax, ang documentary stamp tax should be paid every 5th day of the month. So, from the time of execution of sale, bibilang ka ng ika-5th day of the month, no? But the point is, magagamit, pero mataas na po ang penalty na babayaran. So, if you're capable to pay the penalty, why not? Tingnan nyo po yung mga video lectures natin wherein nakailagay po doon yung mga paano pag-compute ng penalties. Okay? Take note of that. Salamat po, Get Bill. Thank you also. And si Imelda, sabi niya, attorney, 30 years fast na. Till now, di pa nata-transfer pa titulo. Only 200 square meters at nakaposisyon ng family house doon. Hope, nais po, may sayas. Yun nga eh. 30 years na. Oh my gosh. Well, others would just be contented in having the property under their possession and ownership. Pero ang evidence of title nila, no? Or yung evidence of ownership na sa property is just a deed of sale. The property, wala silang owner certificate of title. Sabi nga natin, the best evidence of ownership, yung titulo ng lupa. Because it is a prescriptible and indivisible. But this evidence of ownership, yung deed of sale and everything, these are also secondary best evidence din. O yan, usually, di lang sila magastos kasi, sabi mo nga, kung 30 years na, ang laki ng penalty na babayaran. Ang iba ay na magbayad at sobrang laki. Okay, saan na ba tayo? Valid po ba ang last will kahit may foreigner, sinanding, valid po bang last will kahit may foreigner nag-appeal sa last will? Or need pa ba i-probate kay invalid na ba attorney kung well, ang last will talaga dapat po i-probate yan and let the court decide whether it should be admitted in probate or not. Okay? Should be probated or not. Jericho Daizal, good afternoon, attorney. Ask lang po ng biyenan ko, pwede po ba niya patituluhan ang bahay niya? Patay na po ang mga magulang niya. Ano po first step at kailangan po ba ng consent ng mga kapatid niya? Nakapugod ng bahay niya. So you're saying is that meron pong mana ang biyenan ninyo at basically, admittedly by all the kapatid na kanya yung property na kasi nakandyan na siya, no? Well, if the other kapatid ng nanay nyo o ng biyanan is mag-consent, wala problema. Extrajudicial settlement lang of the estate of the tatay or tatay and nanay, and then with waiver of intestate share. Yun lang po. In favor of the biyanan. Then, babayaran po estate tax. Kung covered sa estate tax amnesty, then good. If not covered, then you have to pay the estate tax amnesty under the train law. And bayaran nyo rin po ang donor's tax. May donor's tax consequence kasi. Kasi mag-waive ng intestate share yung mga kapatid. Yan po ang mangyayari. Jerry Kodaysal. Christopher Hanan, good PM attorney. Attorney, nawala ang mga car adipan documents sa BR noong 2006 pa dahil sa ba. Ano po ang gawin para may refile ang car sa BR? Try nyo po maghingi na certified true copy po sa BIR. And reissue kayo ng car certificate authorizing registration pag nakita po doon, no? Sa system nila na bayad na po ang taxes niyan. Pwede po yan. Lapit po kayo sa BIR. Okay, Evangeline Fortesa. Hello, attorney. Mag-ask pa po sana ako, kaya lang baka hindi na makahabol ulit kasi karating ko lang galing work. Sige lang, no problem. Sabi ni Najela Roblox, iba po ba yung recovery possession ay iba din sa relocation and recovery possession? Ang relocation and recovery of possession, iba yan sila. Pero, isa lang nga yan sila. Magkamag-anak lang yan. Magpinsan lang yan. Iparelocate mo, ano yung area mo, para ma-recover mo yung area mo, para maiging iyo yun. I think naintindihan ko ng ang problem mo, Miss Roblox, no? Mother title, ayun na ibigay ang lupa mo kung saan nung nabili mo, let's say 1,000 square meters. Tapos ay ipahiram ang mother title. Tapos hindi mo mapasplit. Kaya ang sabi doon is i-relocation survey pa, tapos after that ibigay sa yung title, tapos ibigay sa yung possession ng property na bili mo. Isa lang po yan, sa isang form lang, isang petition lang yan. Pagsabayin na yan, bakit iba-ibahin? Pagsabayin na po yan. Nardina Isela, parents own 6 hectare land since 1946. Now, someone occupied and they said they bought it from the Subanin. Ano yung Subanin? Without paying the tax. If I pay the real estate tax, could recover the land? Depende, Nardina, no? Depende what is the classification of the land. Is that the title or not, no? Kasi sabi mo, yung occupied lang. Paano nila na-own? Is the title? Kasi kung title po, yung nga sabi ko maganda kapag title kasi meron po tayong tinatawag na yung imprescriptibility at saka indivisibility of title, which is yun ang benefit kapag titulado ang property, no? So, if it is unregistered land, yan ang problema. Kasi usually, ang issue dyan, ang sino ang in possession in good faith. At sino ang naka-register sa tax deck. Mga ganyang mga bagay. So, yeah, you will be having some, depende, no? Depende talaga sa facts na i-present mo. So, I think you have to better request for the assistance of a lawyer already for that, no? To help you. Okay? Si Butaw, Budi, hi attorney, watching from down under Australia. Thanks sa live reply last time. Yes, no problem. Butan, natawa nga ako sa iyo. Ikaw ba yung nagkwento ng na paano daw niya ang kanyang kapitbahay is naka-encroach sa kanya? Paano daw niya kausapin, in love daw siya sa anak ng kapitbahay niya, anak ng pati. Yan ba yun, Butaw? Okay, si Trinidad Mamaril, blessed afternoon, attorney. 709 square meters ang lupa namin na mga sister brothers. Ko po, nung Spanish pa po, pero nung sinukat ngayon, lumabas sa survey, naging 294. At nahati na ibang pangalan, yung isa for 28, lumabas 281. Depende po kasi ang Spanish title ninyo. Kung hindi po nyo na-register yan sa torrent system, yun nga, sabi ko yung Presidential Decree na pinasa ni Marcos nung time noon, malamang naibalik yan sa alienable and disposable public land of the state, no? And probably na-applyan yan kaya lumiit ang inyong property. Try nyo kumuha ng certified true copy ng title, no? Ng title sa LRA kung lalabas yung Spanish title na yan. Kung lumabas yan, may laban tayo. May laban tayo na pwede mo makuha yung lahat, no? Pero kung hindi lumabas, wala na siyang hindi siya lumabas doon malamang hindi yan siya na-register sa torrent system kaya ganyan. Okay. Jit Bill, baka mag-million views ka sa IRR na extended state tax amnesty. I hope po, sana. Because, I would want that everybody would be knowledgeable about this. Kasi tagal natin itong inantay Diba? Ako rin, nag-antay ako nito. But guys, sige akong process ngayon ng, estate tax amnesty, nakakakuha ako ng order payment from the BIR. Kasi ginagawa ko yung mga extrajudicial settlement na nagka-cooperate lahat ng mga parties, no? Huwag niyo patay ng IRR. Kung nagko-cooperate naman kayo, lahat naman ay pwedeng pumirma, pirmahan niyo na, di okay. Yung IRR nga, sabi ko, para lang po yun dun sa yung short statement kung sakaling i-enforce mo yung the process of payment and transfer of properties are two distinct process, diba? So, yan. Okay, hello attorney. So, hindi na kailangan ng SPA from sibling to file estate. Kailangan pa rin po, no? Ano ba ang ginamin mo hindi na kailangan, Mr. Suma? Yun po bang yung hindi nag-cooperate? In that case, yes. Pero for purposes of transfer, you need the SPA of all or the consent of all. Kaya nga, iba na yung distinct and process. Separate and distinct po yung payment at iba rin po yung pag-transfer. But if you desire both to be done, ay kailangan nyo ng SPA at consent of all. Okay? Malu Soriano, good PM attorney. Tanong ko lang po ang steps kung paano kumuha ng court order. Wala po kasi kami maibigay na secretary certificate na required po ng ROD. Kasi di na po nag-e-exist yung developer na binilhan po ng lupa. So may deed of sale kayo from the developer which is a corporation pero wala na kayong secretary certificate, no? Yeah. Maybe you get ang mangyari kasi niyan kung wala na po, no? For purposes of liquidation and winding up of its business affairs ng developer na yon, you could ask from the SEC, Securities and Exchange Commission, yung pinaka-last filed GIS nila. Kung sining officers, no? Now, from these officers na nakasulat doon is you could demand from them to request from them to execute a board resolution and a secretary certificate. Kasi they are still allowed kahit non-existing na po or non-user na po yung SEC, no? To purposes of winding up the affairs of the corporation nga. They're still allowed to execute that necessary secretary certificate, no? So, you write them a letter kasi nandun may address kasi sa GIS sila saan sila nakatira, padala ng sulat. Ngayon hindi magpayag, then you go to court by parang nag-file ng petition for specific performance, no? To perform an act that they are mandated to do, which is to execute a board resolution and secretary certificate. Okay? Take note of that. Ano po gagawin namin? Thanks. God bless po. Father ko, magulang namin, namatay na po at hindi yun ibinenta at akalahati ng lupa namin binahayan na ng umangkin. Sobrang hirap po namin. Well, Trinidad Mamaril, you have to go to a lawyer for that, no? To claim back what is duly yours. No? Kasi kung inaangkin ng iba, inilan-grab ng iba, pwede po kayong magsunggoy sa abogado para mag-file po ng kaso against that person na umangkin. Okay? Sabi niyong sobrang hirap po namin. Well, there are many, alam mo, pwede tayo lumapit sa PAO, Public Attorney's Office. Marami pong PAO akong kilala na talagang alam po nila ang duties and responsibilities as a public servant. No? Yan, mabait naman. May iba namang PAO na masungit na parang pagod na pagod. Sana hindi na lang sila nag-PAO. Alam nila puro pobre ang nandyan at naghihingi ng tulong nila. Galit pa sila pag maraming tanong. Sinisigawan pa nila. That's true. I have a client, ganyan. They do not listen to their hindi ka lang sana nag-PAO. Kasi ang PAO dapat matyaga kang makinig doon sa mga kliyente. Lahat na mahihirap yan eh. Hindi yung makaintindi ka agad eh. Dapat ipaintindi mo mabuti. And tell them that these are the remedies, itong dapat gawin, ganun. So lumapit po kayo sa PAO. Pili po kayo ng mabait na PAO, lawyer. Kung wala namang PAO, let's say talagang puno and everything, meron po kaming IBP Legal Aid Clinic per chapter. Dito sa Davao City, meron po kaming IBP Legal Aid Clinic. It is headed by a lawyer who handles free legal aid services. Handog po yan ng Integrated Bar Davao City chapter namin. So, and other chapters, meron din pong ganyan. No? Try nyo po hanapin. No? Pag hindi, patulpo mo na. Okay. Joke lang. Si Ronel John Fortunado. Attorney, good afternoon. Ano pwedeng gawin ng isang heir para makuha, ipasurrender yung original mother title na itinago ng ibang heirs at ayaw ibigay? Pwede po yung file a petition for the recovery of the title. No? Kasi to surrender the title. Because that is allowed, no? Even under 1529, Presidential Decree 1529. And when you file a case in court, they will be directed to produce that. Di ba? Anong reason nyo ba di mo produce? Pwede nga mag-file ng judicial partition and settlement. The same time with prayer for a mandatory injunction to require them from producing the document during trial, the title during trial. Pwede hindi yun, ba? Maraming mga remedies under the law. Okay? And sabi ni Dante Obnamia, magandang hapon, attorney. More power sa channel nyo. It helps me a lot. Tanong ko lang po about sa estate tax. Paano po ang sharing sa pagbabayad ng estate tax kung 5 magkakapatid, 4 buhay, 1 na patay? Actually, sa totoo lang, no? Ang magbabayad ng estate tax, yung estate ng patay ng decedent And although in reality, ang mga heirs po ang mag-shoulder niyan, no? But they get it from the property na minana nila. So, paano ba sharing? Kung 4 ang buhay, 1 ng patay, yung 4, mag-share ng 1 share. Yung 1 patay, may mga anak man yun sila, mag-share sila for 1 share ng 1 patay. Kahit kung 5 sila, ambag-ambag sila para doon sa share ng papa na namatay na. Isa sa mga kapatid na namatay. Divided by 5 pa rin. Okay? MB. Attorney, valid po ba ang deed of sale na signed talaga by both parties pero di na notarize agad? Then may third party na kinuha ang deed tapos pinake ang notarization records. Magagamit po ba yung deed of sale na yun? Kasi namatay na ang seller. Okay. Alam mo kung totoo talagang signed siya. It is a private instrument, no? Between the parties. And it's a private agreement between the parties. It's valid, no? Kaya nga, sabi natin, wala namang necessary form ang sale. Basta pag sale po siya, is that any in private, kaya lang, when you go to court, you have to prove, present witnesses who saw that it was executed by the parties. But beside the point, sabi mo nga, valid ba talaga ang deed sale na talagang signed by both parties? Okay. Hindi na notarized agad. Now, ang question mo, may third party na kumuha ng deed tapos pineke ang notarization. Magagamit pa ba ang deed of sale? Well, yes, magagamit naman. Kung let's say fake ang notary, sino ba ang magko-complain? Meron bang magko-complain? Kung wala naman nagko-complain, kasi nga, sabi mo, valid nga naman yung sale, then you present it sa Registry of Deeds and then probably hindi ma-determine ng Registry of Deeds na fake yun. Pero kung ma-determine nila na fake yun siya, sorry, it will not be a registrable deed because it's not a public instrument. Iba naman, nakakalusot, basta wala lang pumapalag, okay lang. Case-to-case basis yan. When you try to assume a risk on something, you present it to the make sure that yung hindi ka mabalikan. Pag mabalikan ka because of that falsified document, delikado. Okay, si Karen G. Attorney, naka-mother title po ang lot, pero di pa nahati sa mga buyer. Naka-hold sa attorney ng seller disease. Buyer A, di-panotate sa title, pero pinakancel kasi kulang yung area nilagay na claim. So, yes, Karen. Buyer A, naka-name sa tax deck na ibenta ni buyer A, portion lupa kay buyer. May transfer. Alam mo, magulo eh. Kasi, basta as long as magkaroon ng paper trail on how the transmission of this ownership from one to another, hawak kasi ng, it can be transferred. Basta, remember, basta, hindi pa nga na subdivided ang property, pagbuo pa ang property, mother title pa, make sure that the property itself on the ground has been subdivided already at may kanya-kanya ng technical description. Kahit na naka-mother title pa yan sa taas, no? Pag meron na ang property is meron ng technical description pa isa-isa at na-identify na kung saan nyo doon, pwede na yung transfer from one person to another. Ang karamitan kasi, ang ginagawa nila, meron ng ganun, dahil hindi pa rin na nakukuha ang title, mag-a-adverse claim sila for that particular portion. Kaya lang, pag itra-transfer yan, later on, mag-carry over talaga yan. Unless that adverse claimant will surrender, no? That will cancel the adverse claim or you file a petition in court for the cancellation of adverse claim. Dahil sabihin mo na yung kiniklaim niya, hindi naman ito yung property ko. Usually, nagkakaroon ng adverse claim kapag walang subdivision. Hindi pa na ibibigay ko ano yung proper technical description para sa tao. Para sila sabi lang, okay, may 2,000 square meters ako dyan, may 3,000 ako dyan, may 4,000 ako dyan. Eh, saan? Saan ilagay ang 2,000, 3,000, 4,000? Wala namang subdivision at wala namang partition agreement. Kaya nag-adverse claim sila. Nadadamay lahat. Kahit ang property is, let's say, 2 hectares. Tapos ang ina-adverse claim lang niya is 1,000 square meters. That's the problem. Ay, basta limuot yan na problem yan. Marami dito sa Island Garden City of Samar. Puro adverse claim, mother title, collective CLOA. Ang gulo. Hanggang ngayon, hindi pa napapatituluhan. So, you will have the same. Alam mo yan sa iyong problem, Karen, is that it takes a while to understand the situation. Talagang with complete papers and everything. Kailangan nyo po talaga ng real estate attorney or real estate planner for that. Isa-isahin talaga, hanapin ang defect. Hindi po pwede kaya dito sa vlog lang natin. Generally, I could tell you. Pero yung step by step talaga mahirap. Kung Davao ka lang tinulungan kita pag-analyze yan. Analyze. Okay. Kung isa kawilan, late again? Oh, no problem. Better late than never. Si Gertrudes, yes, present. No problem, Gertrudes. I'm happy that you are here, guys. And si June Prudencio, very informative and a must for all real estate and prospective owners. Thank you so much for the kind words, Mr. June Prudencio. Salamat po. And si Philstar Real Estate, Idol, iba may copy ako, Revenue Regulation, Tender Report Tax Amnesty, dated September 8. Iba pa yung circular na mabanggit mo. Yes, yung Revenue Regulation mo on September 8, it is, yan yung yung parang dineseminate lang na merong estate tax amnesty. Pero wala pa yung yung circular. Circular na ba yan sa'yo? Revenue Regulation 10? Check ko daw, ha? Revenue Regulation 10. Sabi ni Philstar. Dali, guys, ha? Hanapin natin ito. Very important. Bear Revenue Regulation 10-2023. Hindi ba man ito, bro? I'm opening it. Revenue Regulation August Yeah, so Wala pa yan. Hindi pa yan siya ang ano, bro. Yung revenue regulation mo na 2023. September 8, meron ka. Dito sa website ko, ano, August 3, 2023 pa lang ang revenue regulation number 9, 2023. Wala pa akong 10. Baka meron ka niyan. I-try mo raw, send sa aking messenger, Philstar, Attorney Raymond Bato. I-check ko po daw. Baka pwede mo ma-send ngayon para ma-check ko na rin ngayon sa messenger, Philstar. Tayin ko, brada, kung ano, para ma-explain na natin dito ngayon sa ating mga friends. No? Yan, tayin ko. Alright, thank you so much, Philstar. Attorney, bakit po notarize ang deed of sale kahit walang pirma ang spouse and wala po nakalagay sa dos na married? Eh, alam mo, pamilya, karamihan kasi, ito talaga minsan mga abogado ba, mga sa Bisaya pa, maldito. Yung ano ba, yung maloko ba? May mag-deed of sale. Alam nilang married, tapos walang marital consent. Hindi nalagay sa deed of sale na married. Pagkatapos, later on, pagdating sa ROD, babarahin ng examiner ng Registry of Deeds kasi they required kasi ilagay ang complete details. Married to whom? Kanino ka married? Ano ba to? Conjugal property ba to? Hindi. So, babalik na naman sa abogado. Tapos sabihin ng abogado, ay, walang marital consent yan. But basically, if that is the case kasi, that is invalid sale, no? Kasi walang marital consent. So, very important po. Ay, nako. Sige. Ay, ito. Thank you, si Feliciano. Wait ko lang, idol, ha? Wait ko. Ayan na, nag-chat na siya sa akin. And then, sino pa? Fatima siya. Thank you, attorney. Sorry na busy ako paglilipit ng gamit namin dahil uuwi na ako sa atin. Wow! And for good na po ito, week. Talaga, ha? Wait ka na. Oh, ito. Meron na pala siyang napadala si Feliciano. This is from Philstar, ha? Kaibigan natin ito. Oh my God. Oh, this is it. Yes, thank you so much, Philstar. Bago ito, September 8, 20. Pak, lumabas lang nung Friday. Oh, I'm going to discuss this. Guys, so meron na nga pala, oh. Thank you tayo kay Philstar, ha. Ito na yun, duly accomplished and sworn ETR and death certificate. Kaya lang, hinahanap ko yung ano, bro, hinahanap ko yung sworn statement. Dali, ha? Sworn statement. Installment, to. Dali. Excited tuloy ako na. Sige, maganda ito. Thank you so much, bro. Feliciano, ha. Salamat, Philstar. Wow! Bravo tayo kay Philstar. Ano na pala September 8, 2023, ha? Ba, gawa ako kaagad dito tomorrow para i-present ko kaagad within the week. Thank you so much. Thank you so much. Mag-type tayo sa kanya na, thank you so much. Yes! Yan, ito ang kachat ko. Kita ba nyo ba? Yan ang mga nag-chat. Sorry po, ang iba hindi ko nasasagot. Si Aldrin Bulong, yan. Talong ko sana kung ang mag-file ng recovery possession. Oh, ito pala si Aldrin yung kanina, no? Kung mag-recovery possession sa recovery title ay magkaiba ba ang acceptance fee niya? Dito pala, no? Okay. So, marami. Meron din ako mga message request dito na hindi ko pa nasasagot. Oh, I'm sorry. Wala pa bang update? Meron na. Guys, I'm sorry kung minsan hindi ko kayong masagot ha. Kasi talagang within the week, sobrang busy. Okay. So, ano na po? 6:42. So, maybe I will be discussing again. Si Robert, salamat po. Robert Malikse. Si Caron, message mo na lang ako bro, para at least masagot kita. And si Abs Lazera, hello. No problem Abs, basta as long as nandyan kayo. Happy na ako yan, nakikinig kayo. Manoodin nyo na lang yung replay natin, no? Para mabasa natin lahat. Si Eman, si Wadas5, and everyone else. Guys, pakiano na lang, please. Or pwede ko naman ito, teka ha. Dali pwede ko ito siya i-clip Try ko ito. Yan. Alam niyo, pwede natin ito siyang i-save yan. O, tingnan mo ang gagawin ko ha. I-save ko ito mga question nyo. And I'll try to post it na lang. Ayan o. Yan o, nakalabas na o. Yan o, save na yung question nyo dito. Yan. See that? That is your save. So, i-save ko siya o. Kasi sa screenshot. Live. Screenshot. So, nandun na mga question nyo guys. Sagutin ko na lang para at least hindi na makaya. A bit makati na po ang ating. Salamat po masyado sa inyong lahat sa pag-watch po natin. So, already 6:44 p.m. Gabi na po sa Sunday. And kahit na po, hindi ko pa kayo nasasagot, please lang po, i-try nyo lang mag-send sa messenger ko. And hopefully, pag makabakante tayo, masagot or matawagan ko man lang kayo para mas mabilis po, no? Sorry kung hindi ko kayo masyado na-entertain, but I'll try my best, no? Itong forum natin dito, ma-exit talaga masyado, no? Tsaka, di makaya ng laway. Talagang masakit na sa ubo. Okay. So guys, thank you so much. I'll see you again. And thank you po kay Philstar Brokerage Realty. Kabatch po ito na real estate broker. Sa Feliciano, salamat po masyado sa meron na po tayong implementing rules and regulation. And tomorrow po kagad gagawa ako ng video lecture on this. And hopefully, everybody will have a knowledge about these implementing rules ng ating estate tax amnesty of 2023. Maraming salamat po and I will see you again next time. Bye-bye. Eating time, lunch.